Okay. Yes, see how Casey might put something right there. This is next week's topic. On the record, in the matter of the people of the state of Michigan versus Kennedy Atkinson, file number 24-02062, council appearance.
Good morning, Your Honor. Tessamari Coni, appearing on behalf of the people. First, making a motion to practice under Michigan Court Rule number 8.120.
Good morning, Your Honor. Toby White. I'm here on behalf of Mr. Atkinson by Zoom, as is Mr. Atkinson present by Zoom.
Okay, with the date and the time that was scheduled for preliminary examination. 2 counts of criminal sexual conduct, first-degree assault with a deadly weapon, and 2 counts of felony firearm. How are we proceeding on this?
Your Honor, at this time, the people will move to dismiss in the interest of justice based on a lack of probable cause. May I make a record?
You may.
We have received several communications from the complaining witness on this one, Nicole Blazer. We've sent detectives out to investigate. We've heard from defense counsel as well, who's provided us with some documentation. The long story short of it is there have been several different versions of what happened told. There have been statements about lying to the police that have been made, and there are several different versions of that type of a statement. So we are unable to proceed because of a lack of probable cause.
Okay. Are you prepared, Anali?
I have not. I apologize.
Any objection from the defense?
None, Your Honor.
Okay, motion to dismiss is granted without prejudice. Do you have any questions for the court today, Mr. Atkinson?
What will I be able to get my tether off for house arrest today?
Yes, you would need to report to Ingham County to have that removed.
Okay.
Any additional matters for the record, counsel?
Nothing further from the people.
Just I appreciate the prosecutor's office discretion in this matter. Nothing further.
You're all set.
Thank you.
Okay. Ariana Duke here.
Yes.
Duke. Ariana Duke. We're checking the court. The record in the matter of the people of the state of Michigan versus Ariana Duke, file number 24-02437.
Good morning, Your Honor. Tessamari Coni, appearing on behalf of the people.
Do we know where Mr. Milks is? Have you seen Mr. Milks?
Sure, if another public defender wants to fill in, but I have not seen him do any witness on this one, Your Honor.
Mr. Farmer.
Yeah.
Appearance for the
Thank you,
record.
Your Honor. Robert Palmer of the Public Defender's Office, standing in for Assistant Public Defender Steve Milks on behalf of the institutes.
Okay, Mr. Dukes, today was the date that was set for preliminary examination. This is for imprisonment and domestic violence. Counsel.
Yes, Your Honor. At this time, the necessary witness, Jermain Hoskins, has failed to appear. I have had conversations with him. He made very clear that he wanted nothing to do with this case, so the people are unable to proceed.
Counsel.
And thank you, Your Honor. At this time, defense would move to dismiss the lack of probable cause.
Motion to dismiss is granted without prejudice. That means that the people have the right to reissue this charge against you, okay? Do you have any questions? You have a seat. We'll get you a copy of your dismissal in just a moment.
Oh, yeah, and Your Honor, just she has a tether on. I'm assuming the court can notify JSG.
Yes, she'll be able to go down to Ingham County, have it removed. Is you not, so Milks is not in another court, we just don't know.
I haven't seen him at all this morning.
I also haven't seen the necessary witness on Shaw, Your Honor.
Give other piece.
I don't think I've seen the defendant on that one. Jermain Shaw.
He's in custody.
Okay.
What about Calvin, Shaun Calvin?
Shaun Calvin, we're gonna amend the complaint on that one, Your Honor.
He's in custody as well. Samantha Decker here,
Yes, ma'am, she's here in the hallway.
on the record in the matter of the people of the state of Michigan, versus Samantha Decker, file number 24-01888. Counsel here.
Good morning, Your Honor. Case Markarian appearing on behalf of the people.
And good morning, Your Honor. Robert Palmer, Public Defender's Office, on behalf of Ms. Decker, who's standing to my right.
Thank you. How are you, Ms. Decker? Did you get a probation firearms? Okay, Samantha Decker. Okay. This date set for sentencing. I have a pre-sentence report that was prepared back on August 27th. Counsel, did you get a copy of that?
I did, yeah.
Yes, Your Honor.
No. Do you make corrections, updates, or deletion?
I do not. The only other thing I would note, Judge, is that Ms. Decker has another matter that's pending, or she's now on probation for down at 55th District Court. As part of that, she was ordered to have a substance abuse assessment done. She did bring me a copy today in the event that the court wanted to see that. I don't believe it was ordered as part of this file, but she does have one done. And I know that alcohol was a concern as part of the offense.
I did order a substance abuse assessment.
Did the court have a copy of that?
Oh, there's not one in my file.
Judge, I brought an extra copy if the court would like me to approach.
Oh, yes, there is. Why wasn't this provided to our probation department earlier?
I was struggling to find transportation to get it done, and I saw Mr. Palmer the very next day after I had it completed.
Okay, make allocution.
Thank you, Your Honor. Certainly, Ms. Decker has made some mistakes here. She takes responsibility for that. I think that's reflected in the PSI as indicated. She acknowledges, or the PSI indicates the defendant was honest that she believed her parenting skills could be improved and she could use some work in managing her anger. Certainly, Ms. Decker takes responsibility for her actions on that particular day. She recognizes that she was going through a difficult period in time in her life. She was certainly struggling. She is trying to make amends at this point. She has, I believe, attempted to follow all of the conditions of her bond. She has been trying to obtain employment. She's applied at a number of places, and she actually had thought that she had a job working at Denny's, and they ended up not hiring her because of wanting to know what was going to happen with this case. But nonetheless, she continues to apply for jobs and is hopeful that she will find employment in the very near future. I will point out that Ms. Decker has attended all of her court dates. She has been in compliance with pretrial services, or was when she was required to do so. She has a limited criminal history, certainly not none, but a limited criminal history. I certainly think that Ms. Decker is capable and willing of completing a term of probation. That is the recommendation in the PSI, and I would ask the court to follow that. I would also note that she is also on probation at 55th District Court as well. So she is kind of complying with two courts' different orders.
The client want to make a statement, Will?
No.
That was a no.
No.
Ever reviewed her prior criminal history and the pre-sentence report, and now I reviewed her substance abuse assessment. And the probation department did have concerns based on some of her answers about alcohol being an underlying issue, at least especially in this incident that brought her before the court today for sentencing. How long is she supposed to be on probation?
I believe her anticipated discharge date, Judge, is May of 2025. So she's got about, what is that, 9 months roughly? 10 months.
The substance abuse assessment seems to be more concerned about her statements about her nicotine use. Tobacco use, I should say. However, when I look at her prior criminal history and I consider factors relative to her impairment or mediation during the instant matter, I have concerns about her sobriety regardless of the issue or the assessment. And I know that it says that she's not had a drink, at least at the time that she was assessed, for at least 2 months. Is that accurate?
Yes, ma'am.
So you're taking some measures to try to address any substance abuse issue, correct?
Yes.
I think a term of probation is appropriate. I am going to place her on probation before this court. So she will be monitored by 2 courts during this next 9 months at least, because I'm going to do 9 months probation. On probation, you have the following conditions. You're not to engage in any assaultive or threatening behavior. You're not to purchase or possess ammunition, firearm, or weapons of any kind. You're to attend parenting classes. And obtain and maintain employment. And you must provide verification of both, okay? You're also required to comply with all your conditions from the 55th District Court probation. Not to use, purchase, or possess alcohol, marijuana, or controlled substance, and you are responsible to pay for your submission to random preliminary drug testing and your analysis testing while on probation, okay? You're not to be in any bars or nightclubs. Do you have any questions at this time? You will be reporting via Zoom. It's a $30 per month probation oversight fee that you're responsible for. There's a $75 crime victim rights fee that must be assessed, plus a $50 state minimum cost that also will be assessed. I'll waive discretionary fines and costs at this time. So it's $395 in total fines and costs and oversight fees. You will be able to make monthly payments on that, okay? I understand that you're currently looking for employment, so until you are gainfully employed, you are gonna probably want to prioritize the payments for the testing over paying that $395 down. We can address the $395 later. You're employed, okay? You don't want to skip your testing. She ordered to test in 55th.
I believe she was.
So if there's no reason why you need to test. Let's say you were testing, you get drawn to test both days, that's fine, but if you were told to test one day at one court and then told to test at another day, I think you should be able to notify your probation officer so that you're not over testing. So I'm going to note that here. Lastly, there's an advice of rights as to probation. Being placed on a term of probation at the 54A District Court, and your terms are being individually tailored and are specific to address your assessed risks or needs. Goes to the defendant. And you need to review that. That advises you of how and when you would be eligible to request early discharge from probation. You must first complete half the original term ordered by the court. You cannot have had any violations within the 90 days preceding any request. If you make such a request, you can get the form off the court website. It's the MC 512 form. You fill out that form, you file a copy of it with our probation department, and you have to serve a copy of it on the prosecuting attorney's office. The prosecutor has 14 days to file any written objection to your request for early discharge. If for some reason I set it for a hearing to address your request for early discharge, you have the right to hire an attorney to represent you. You do not have the right to court-appointed counsel for any hearing for early discharge. For your record, I've never held a hearing for that, okay? But if for some reason I did. Do you have any questions about that? You just need to sign that you understand that. Yes, please. When you are all set, you'll go downstairs, check in with our probation department so they can ensure that they have accurate information for you. We'll have to go over my judgment of sentence once they get it drafted up. But do you have any questions at this time, ma'am? Any additional matters for the record, counsel?
Nothing from the people.
Nothing further. Thank you.
You're all set. Thank you. Mr. Etheridge has Konecki in custody.
Yes, Your Honor.
We can have her brought up. Catherine Fleming,
Good morning, Your Honor.
good morning. Did I see Mr. Hayes? Ms. Fleming, are you here on behalf of the defendant?
I am Mr. Giovanni Valladares.
Is he going to be logging in?
I'm not sure, Your Honor. I will give him a phone call if you'd like me to.
Wow. Supposed to be a hearing for bind over or not bind over. So he's probably got to be here. Or he's gonna get a bench warrant.
I will give him a call, Your Honor.
Thank you. Mr. Mills, pleasure of you to join us today.
Pleasure truly is this court's.
Is
Please don't put me in jail again.
it? You are representing Mr. Shaw.
Yes,
You
sir.
owe Mr. Palmer because he had to pick up your slack while you took your time
Yeah,
getting here
he's
today.
making me give him a pedicure again, so.
No, Starbucks.
Starbucks.
Maybe
Seems fair.
little Starbies.
Yep, he wants a venti.
That's
Yeah.
That does sound like him.
Yep. Okay, Shaw, we can bring Shaw up.
Yes, Your Honor, I haven't seen the necessary witness on
We
that.
need to bring him up.
Yeah, I don't know if
You
we
may not need to bring him up. I'm gonna talk to him.
On the record in the matter of the people of the state of Michigan versus Jermain Hezekiah Shaw, file number 24-02524, council appearance.
Good morning, Your Honor. Tessamari Coni appearing on behalf of the people.
Good morning, Your Honor. Stephen Milks on behalf of Mr. Shaw. Mr. Shaw is currently incarcerated in LPD lockup. Following this hearing, we'll go down and speak to him regarding the results.
Okay, today was the-
Anticipate results.
Thank you. Today was the date and the time set for a preliminary examination. A 4-count complaint with an habitual offender fourth offense notice. Counsel, how are we proceeding?
Your Honor, at this time, the necessary witness, Kathleen Albany, has failed to appear. I have made contact with her. I was expecting her appearance today, so I am surprised by her not being here, but admittedly, this was not when our office authorized to run victim lists, so we are unable to proceed.
You spoke to her when?
Last week, Your Honor. It was an interesting conversation to say the least. I think she was on the fence of whether or not she wanted to participate, but I had emailed her a subpoena.
Counsel,
Thank you, Your Honor. As the people are not prepared to proceed today, the defense being ready and able to go forward with the preliminary examination, we are requesting a dismissal at this time.
the motion for dismissal is granted without prejudice. You can advise your client that people have the right to reissue this charge against him.
Will do, Your Honor. Thank you. Of course, okay. If we can probably take care of this as well.
Mr. Wiggins,
Yes, Your Honor.
Taylor,
Sorry, I couldn't hear you.
what's your name?
My name is Taylor DeSanto.
Why are you here via Zoom?
I have a court hearing this morning.
And
He's the co-defendant to my client, which is Dominic Camacho. This is the matter, it's scheduled for prelim, but we were gonna treat these as PCCs because Ms. Donnelly was originally representing Mr. DeSanto, but she had to conflict out because I had a co-defendant and the court had indicated we would treat today as PCC.
Oh, okay.
Both defendants.
And there's not been conflict counsel appointed yet?
I looked, Judge, there was a Jack Rucker, I think, was who, I don't know, to be clear. He was, according to the notes, I just looked at this yesterday, according to the notes, he was assigned to Mr. DeSanto, but it's not clear whether he's ever actually filed an appearance or I don't know whether, I have no idea whether it's in
Okay.
contact with Mr. DeSanto.
Okay, sounds good. So we're treating these as PCCs. Mr. Desano, hang tight. It's just 9:30. Maybe your new attorney is on the way.
Okay, thank you.
Oh, I'm gonna put you on mute in the meantime. Let's see. Mr. Goodrich, you have Marcus Jefferson here? Oh, Mr. Goodrich is not in here.
I believe they are both here, though. I think he's talking to Mr. Decker for some reason.
Are you Mr. Jefferson?
Yeah.
Okay, so Mr. Jefferson's here. You spoke to your attorney already? Is he outside?
Yeah, he said he thought it'd be long, when we grab him.
Well, I'm just trying to figure out, are we running that one?
My understanding, we are, yes, sir.
Okay, you can have a seat.
Where?
Thank you. You can have a seat. We'll wait for him. Okay, let's see. Mr. Austin, you have Eric Mass.
Yes, Your Honor.
We're running that one as well.
Yeah.
Okay. Hi, sir. What's your name?
Attorney Jackson.
There we go. Okay. You're representing Mr. DeSano?
Yes,
Okay, have you spoken to him?
I have not.
He's on Zoom, so you might want to log in if you'd like to speak to him.
Very good. I'll go into a conference room. Thank you, Your Honor.
No problem. Okay, she's bringing someone up now. I think it's Mr. Etheridge's client, and then we can. Since Mr. Austin is here, we'll start with masked.
Start with Mass, Your Honor.
Yes.
You
You
mind
want
if
to
I-
call Wiggins?
Yes, Your Honor.
Running that?
Yes, he wants to run mask.
I got Shaun Calvin downstairs, who were just amending.
Yeah.
Okay, I understand. She's going to bring one up at a time.
Yeah.
So we'll do that before we start. On the record in the matter of the people of the state of Michigan versus Diamond Wiggins, file number 24-02433, council appearance.
Good morning, Your Honor. Case Mark Hearing, appearing on behalf of the people.
Good morning, Your Honor. Stephen Milks, on behalf of Ms. Wiggins. Ms. Wiggins is present and standing to my right.
How are you today, Ms. Wiggins? Today's the date set for preliminary examination on home invasion first. How are we proceeding?
Your Honor, at this time, we will be amending the complaint on this one to entry without permission to keep it in district court. Additionally, Your Honor, there's been an updated offer made on this just this morning when Mr. Milks came in. I'd like to advise the court of. We had already talked about working out a global resolution to include the pending child abuse fourth charge that's set for jury trial in this court. Ms. Wiggins has also picked up an assault and battery charge that is still in review and has not been issued yet. The updated offer is to plead guilty on the child abuse fourth case, and we will dismiss both this case in its entirety and not issue the one.
The one in review, what is the alleged date of incident?
Alleged date of incident is August 21st, Your Honor.
Thank you, Your Honor. I don't think there's much we can do regarding the amending the complaint at this time. Obviously, we need to talk further with my client as well as Mr. Raleigh, who's her attorney, I believe, on a misdemeanor matter regarding this global resolution. So we just ask the court obviously separately.
Okay, so this is being amended to what again?
Entry without permission, Your Honor.
Maybe set this on the misdemeanor docket.
Yes, Your Honor.
The trial? Yeah, when is that one? Sometime that day. We can set it before then. It might actually have to be on the date. I think that's our next available. October 1st. But at 8. At 8 a.m., which is the date of her jury trial. Wiggins, do you have any questions for the court today? So we can hear you. No. Any additional matters for the record?
Nothing further from the people. Thank you.
Nothing from the defense. Thank you, Your Honor.
Okay. We'll get you your notice to appear. You can have a seat.
I haven't checked in the hall.
Yeah,
She's off. I got a moment to go check. I wanna go check.
Yeah, that's hers.
If there, I got emails back.
Thank you.
So.
Yeah, no, he's good.
Yeah, absolutely. He's good. I like him a lot. Yeah, I'm happy to hear too.
I mean, he's gonna give us problems. He's good. I mean, he's legit. Right.
So you gotta go all the way down. I'm sorry.
Yeah, that pre. Then you get all the body cams, and the presentation asking all the right questions. Yeah, he's solid. I mean, maybe sometimes we can explain.
No, I just don't.
Play the elements or whatever. But I was like, he's got you covered, dude. Yeah, I just wanted to. Remember you waved at there. That's right. That's right. Yeah. Yeah, that's like, yeah, CCWR. Yeah. And he's like playing all the videos and asking all the foundation questions. I was like, I don't even have anything to object to. What you want me to do? It's a good one to get. Bills it. Yeah. And he was like telling me before that, he's like, I'm gonna play it. He's like, I'll play longer if you want, but I'm only gonna play like from like 1346 to 1427. Okay, fine. I don't even know what that shows, but okay. Fine. Play it, we'll learn it together. Can't wait. That's right. Then Clark was down. Wasn't he down? No, I think he wasn't. No, I think he was. What is that? Well, Clark is on fifth. What is that? When did I used to be Courtroom on fifth? There was. You down as with the class. For a little while. Yeah. Yeah, I think the weekly was losing. And then because what's his name was down on police in the big photo, and Sherry.
All right.
I know.
See that?
Around a long time.
So, Mr. Plummer, can you turn that fan on first, please?
You have a particular speed? Much.
That's too high. Yep. One more. Thank you. Okay, let's see. This is for what quick. But you have Conkey. Okay, on the record in the matter of the people of the state of Michigan versus Tamara Lynn Conkey, 23-00834, council appearance.
Morning, Your Honor. Casey Markarian appearing on behalf of the people.
Morning, Attorney Derek, it's also public defender on behalf of Ms. Conkey, who's in the courtroom standing to my right.
Okay, today's the date and the time that's scheduled for a sentencing. I do have a pre-sentence report and recommendation. Council, did you get a copy?
Yes, Your Honor.
Corrections, updates, or deletions?
Your Honor, in my calculation of the days in custody, it was 81 rather than 80. I don't know if they didn't count today because it's sometimes they count it at midnight after today's over with.
Okay, sounds good.
That was the only deletion or correction I had.
Make allocation.
Your Honor, as the court knows, Ms. Conkey has struggled with addiction. At her plea, I had her bond revoked on this case as well as all the, well, at that time, I think the misdemeanors ended up getting dismissed as part of the package deal. But she was afraid to get out of jail because of her struggle with narcotics and that she would go back to using. So she's been in jail pretty much the entire time that this case has been pending. I looked through the recommendation and went over the recommendation with her, and she accepts what probation is recommending, but she does agree that it's highly unlikely that she's going to be able to complete it because of financial issues. She has been going to jail, or at the jail, been going to CATS and other programming for her substance abuse issues, as well as her GED. As this report and shows, she does suffer from some mental health issues from the past. It talks about numerous ones that the court is aware of. I won't place on the record, but it's in the report itself. She does have severe addiction, as indicated by the assessment that was completed. She does have these outstanding bench warrants pending in Eaton and Clinton County for misdemeanors, and I think one for child support in the circuit court, which I think is a civil matter, not a criminal matter. After reviewing everything with her, she would ask the court to follow the recommendation. She would ask the court to consider maybe a lesser term of jail. She has been doing services at the jail, and she does have some stuff pending that she would like to get resolved. She would ask the court to find her indigent and waive any fines, fees, or costs the court can waive. There was, as part of the plea agreement, an agreement to pay restitution. It's not recommended. I talked to the prosecutor, and he's going to place that in the record for the court. Thank you, Your Honor.
That is correct, Your Honor. The amount of restitution is in total going to be $490 on one case, $172 on the other. That brings us to $662.
Have a restitution form.
I can fill one out. All right.
So she's not disputing the restitution amount. Any further allocution?
Your Honor, I have no further allocution, but Ms. Conkey does have a statement or a letter she'd like to read to the court at the appropriate time.
You can do so now.
I just want to apologize for the actions that I taken to the victim, who I took the things from. That I'm sorry, and I want the court to know, for the first time in a long time, I finally recognized the woman staring back at me in the mirror. I was so lost in my addiction, I no longer knew who I was. I honestly believe jail has helped save my life. Since I've been here, I've been clean for 80 days. I've attended therapy with CATS, GD, and breakout classes. The classes have given me insight into why I am using and how to think differently on purpose. how to take away my uncertainty and what I am doing and find the strength to change. I realize that I haven't lost this fight. I've made it through the worst of it. Didn't break me, and it didn't break me. My time it's my time to stand up and move forward with my life. While I'm thankful for the time I've been here and what is done, I'm ready to honestly start my new life and utilize what I've learned. Thank you for taking the time to listen.
Thank you for taking this opportunity to address or to address the victim, even in the victim's absence. I think it's wonderful that you have your attorney here, but it's always meaningful when you are willing to say something and acknowledge the actions that's happened and how you want to move forward. So I appreciate you addressing the court. I reviewed the pre-sentence report and the recommendation, as well as the defendant's prior criminal history. And I recognize that she has several bench warrants or retainers that are pending in other jurisdictions. I think that the recommendation is appropriate. She's benefited from being in custody and from not being exposed or in a position where she has not been able to control addressing the underlying issue here, which is some substance and some maybe not properly treated mental health issues. I think that she could get on track to return to society and be full functioning, but that's up to her. It's up to you, man, what you want to do. And you need some tools for that. I'm glad to see that you've been participating in some programming. And that you found the foundation for some sobriety, but I would like to see you get stronger so that you're not continuously cycling through the system, which is where you were up to this point. But it's up to you to break that stride and decide that you're going to do something differently. You've not been successful on probation. So I think a term of jail time is appropriate. I'll adopt the recommendation. The sentence is for 180 days with credit for 81. While in custody. The recommendations for you to participate in the jail services to continue to obtain your GED. And other substance abuse services that are provided along with participating in the CATS program, okay? Is that a yes?
Yes, ma'am.
We have can I have the amount for restitution again?
$490 on case number 2300834FY. And I'm just trying to find the other case number, Your Honor, but it's $172 on that one.
Well, I only have one case here today. There's 2 counts. Essentially, is what happened. So I think the count, she pled guilty to count 2, breaking it and entering a vehicle and an added count of financial transaction device. So count one is,
Your Honor, the additional 172 was for one of the cases that was being dismissed. It was being added to this restitution was added to this case. It would be totally different.
I can't, we're restitution on another, it's gotta go under this. You know, restitution on dismissed case.
You want to use the same case
Yes.
number then? Okay,
It has to go under the open case.
so it's $662 total. then.
$662. $662 restitution will be ordered to the victims. $75 crime victim rights fee that will be assessed with a $50 state minimum cost that will be assessed. I'll waive discretionary fines and costs, and then we'll set this for a show cause. In about 6 months, so that we can find out where you are and how you're gonna pay this back, okay? Have any questions for the court?
No, later.
It's a for a show cause. Are we able to set anything next year? Next year's calendar? Huh? We can't set anything next year. She didn't do the. Our calendar is not rolled out for next year yet, so we'll have to get you a date later, okay? Any additional matters for the record, counsel?
Further from the people.
Not from the bench, Your Honor. Thank you.
Thank you. All set. Thank you. Ms. Donnelly needed some, Calvin,
Calvin.
can you bring up Shaun Calvin? I'm resetting Valladares. Mr. Valladares, did you forget about your court date today? I can't hear you, you're muted. Mr. Valladares, can you unmute your device? Mr. Valdez, did you forget that you were supposed to be in court at 9 a.m. today?
Yes, ma'am. I forgot I got the time mixed up, Your Honor. I'm sorry about that.
Okay, it doesn't appear that you have a good connection. I was resetting it anyways because you're over an hour late. You missed your time, so it's gonna be reset. You need to be on time and you need to have a good and stable connection, okay?
Yes, Your Honor. That's why I came outside. It's kind of hard for me to get connection inside the house.
September 27th at 1:30.
September 27th at 1:30.
Thank you, Your Honor.
Thank you, Your Honor. Have a good day.
Thank you. Let's see, we're gonna run Jefferson and we're gonna run Mass.
Yes, Your Honor.
Set that one. Sentencing on that one. Are you free to go, Mr. Valladares? Let's see. On the record in the matter of the people of the state of Michigan versus Dominic Camacho, file number 24-02559, and people of the state of Michigan versus Taylor Desano, file number 24-02560. Council appearance, please.
Good morning, Your Honor. Casey Markarian, appearing on behalf of the people.
Good morning, Your Honor. Robert Palmer, the Public Defender's Office, on behalf of Mr. Camacho, who I believe should be appearing.
And he is on Zoom and Mr. Desano is on Zoom. If you can both start your video.
For the record, Your Honor, Jack Rucker, not appearing on behalf of Mr. Desano.
Okay. Today was the date set for an exam, but I said I would treat today as another probable cause conference because of the issue of needing conflict counsel. I have Mr. Rucker on one. Did you file an appearance?
I filed a substitution of counsel. Your
Oh,
Honor.
a substitution. Okay, when did you file?
I believe it was last week, on Thursday.
You don't have it.
I can forward a copy of the email. I sent
If you could do that, could you send it to Judge Simmons' courtroom
Absolutely.
at lansingmi.gov?
Judge Simmons courtroom at lansingmi.gov.
Yes. That way I can make sure it's signed in the file. Okay. Are we continuing to examine these?
Your Honor, I've had good contact with Mr. Camacho. Mr. Camacho and I do desire to run a preliminary examination on this matter. I think at this point, we just need the court to give us a date to.
Okay, sounds good. So for your information, Mr. Camacho, as well as yours, Mr. Desano, you both have the right to have preliminary examination within 21 days of the day that you were arraigned. You were arraigned back on the 29th of August, but due to the co-defendant needing a new attorney assigned and conflict counsel recently being placed on this case, I'm going to find good cause to go beyond the 21 days so that I can reset this exam for a new date, okay?
Yes, ma'am.
November 1st at 9:30. November 1st at 9:30.
Fine for me.
Works for you, Mr. Rucker?
I'm checking it now. No objection, Your Honor.
November 1st at 9:30, in person at the court. Bonds in each matter, actually for Mr. Camacho was 2,500 personal recognizance, and bond for Mr. Desano was 2,500, 10%. They will continue. Any additional matters for the record?
Nothing further from the people. Thank you.
Nothing further on behalf of Mr. Camacho, Your Honor. I'll just say he's stayed in good contact with me, and as far as I know, is completely compliant with bond.
Okay, sounds good. Make sure you stay in contact with your counsel. If your number or address change, it's your responsibility to notify the court immediately, okay?
Yes.
Yes, ma'am.
Yes, ma'am.
Thank you. You're all set.
Thank you. Have a good morning.
Thank you. Have a good one.
Your Honor, going back to the Conkey sentencing matter we just handled, I communicated with Elena Cisneros. You should already have a restitution paperwork. done.
I know when you're. Oh, so.
If not, I can send it over again, but I do have the email where she forwarded it or sent it to Addie originally.
Or criminal traffic email, is that their?
Well, we're done at that. I gotta
It's on a
I just wanna
red
make
sheet
sure.
of paper.
Okay. Send it to the right place.
That I
Normally-
don't know, Judge.
Yeah, there's no
But,
restitution
yeah.
form in the.
That's what's yours, right?
This typically should be.
It is on a big sheet, Your Honor.
Yeah, it should be sent with these, but if she sent it, I don't have it.
You want me to resend, Your Honor?
Do we have a copy restitution form in your email? You said Elena
Did back in July. If you want me to just resend it, I can do that. I got no problem with it. It looks like she had the nollies and the restitution.
What? We're doing a plea on quick.
Plea on quick, yeah.
The sheet
Yes, Your Honor. And a restitution form.
on the record in the matter of the people of the state of Michigan versus Crystalline quick, file number 24-02397. Council appearance.
Morning, Your Honor. Casey Markarian appearing on behalf of the people. Good morning, Your Honor. Jacob Snartz, the fourth assistant public defender appearing on behalf of Ms. Quick. Ms. Quick is president of council table. She's standing at my right.
Okay, Ms. Quick, how are you? Well, council, you can approach with the plea sheet.
Plea sheet and restitution form, Your Honor, approaching.
Okay, let's see. Okay, I have a plea sheet here. It says that people are offering for you to plead guilty to embezzlement, agent and trustee, $200 to $1,000 under MCL 750.1743A, misdemeanor maximum penalty, 1 year and or $2,000 in fines. There's a sentencing agreement, also known as a kilogram, no upfront jail. And you are agreeing to pay restitution to Dollar General in the amount of $7,943. Is that complete and accurate as to your understanding of the plea offer? You want to accept that, ma'am? I'll raise your right hand. Do you other right hand? Do you solemnly swear or affirm the testimony you're going to give us the truth and the whole truth under penalty of perjury? You can put your hand down. I have an advice and rights of the information sheet here. This is 2 pages, but this page bears a signature. Is that your signature? Okay. And you've read this document?
Yes, sir.
You understand the rights here?
Yes, sir.
Do you have any questions about these rights? No. And are you willing to give up each of these rights today in order to enter a guilty plea to the embezzlement, 200 to 1,000?
Yes, sir.
That means you're gonna give your right to the presumption of innocence. You're innocent until proven guilty. You have the right to require the prosecution prove your guilt at trial by proving each element of the charges being brought against you beyond a reasonable doubt. You have the right to remain silent at trial and not have silence be used against you. You have the right to subpoena witnesses to testify for you, present evidence that you believe show a defense to these charges. You can waive your silence and testify at your trial on your own behalf. And you have the right to see, hear, and question any other witnesses called. Those are all rights you would have to give up. You understand that? Is anybody threatening you to get you to give your rights up?
No.
Has there been any promises extended to you in exchange for you entering a guilty plea today?
No.
Are you currently on probation or parole?
No. No.
You said no?
No, Your Honor.
You understand that by pleading guilty, this could result in a conviction that you may need to report to a future employer or your current employer.
Yes, Your Honor.
This conviction could also have impact on travel or immigration status that you.
Yes, Your
as to the amended charge of embezzlement agent or trustee 200 to 1,000. How do you plead? Factual basis.
Thank you, Your Honor. Ms. Quick, back on April 26th, April 25th, were you employed by a chain of stores called Dollar General? Were you employed by
Oh,
Dollar
I'm so
General?
sorry. Yes, yes, I was. I apologize.
That's okay. In what capacity were you employed by Dollar General?
I was struggling.
And in your capacities as store manager, you were responsible for handling bank deposits, correct?
Yes, sir.
And you had access to a safe,
Yes, I did.
and in that safe, they had cash deposits that were meant to be transported to the bank for deposit in a banking institution, correct?
Yes, sir.
And on or about April 25th or April 26th, in that time frame, you went to the safe, which is located at a store location, 3215 South Martin Luther King Boulevard in the city of Lansing, County of Ingham, in the state of Michigan, correct? And you went to the safe to retrieve some deposits, two separate deposits, correct?
Yes, sir.
And in these bags contained approximately $7,943 in cash, correct?
Yes, sir.
But you did not, as you were authorized to do or instructed to do, take the money to the bank, correct?
Yes, sir.
Instead, you took the money home, correct?
Yes, sir.
And you used the cash to pay some of your medical bills, your phone bills, some of your own personal expenses, correct?
Yes, sir.
And you did, by taking this money, act without the authority of Dollar General, correct?
Yes, sir.
And later on, May 13th, you talked to loss prevention and you talked to law enforcement, correct?
Yes, sir.
And you admitted to them that you had taken the money for your own purposes, correct?
Yes, sir.
Thank you, Your Honor. Nothing further.
Questions from the prosecution?
People are satisfied with the factual basis. Thank you, Your Honor.
Court accepts your plea. I find your plea to be freely, voluntarily, and intelligently made. The matter is set for sentencing November 7th at 9 o'clock in the morning. When you leave here, you go down 1 floor to probation so you can check in, so they can get you prepared for a pre-sentence interview, okay? Do you have any questions for the court at this time? No matters for the record, counsel.
Nothing for the people. Thank you. Nothing for the defense, Your Honor. Thank you.
You're all set, ma'am.
That's sentencing date, Your Honor. I apologize.
November 7th.
Thank you.
Let's see, Mr. Shaun Calvin.
Yes.
Okay. On the record in the matter of the people of the state of Michigan versus Shaun Calvin, number 24-02534, counsel appearance.
Good morning, Your Honor. Case Markarian appearing on behalf of the people.
Assistant Public Defender Sarah Donnelly on behalf of the defendant Shaun Calvin, who is to my right.
Okay. Mr. Calvin, today was the date originally scheduled for preliminary examination. And a police officer saw him breaking and entering without order of permission. How are we proceeding today?
Your Honor, at this time, we will be amending the complaint to an attempt resisting an obstructing charge, so that way the whole case can stay in court.
Okay, so we need to have this reset for misdemeanor docket.
Yes, either pretrial or to see if what kind of offer they'll be giving, or if I don't pretrial, don't matter to the defense.
October 1st at 10:30. October 1st at 10:30. you have any questions for the court today, sir? Any additional matters for the record, counsel?
Nothing to the people.
Not from defense.
You're all set. Let's see, who else is in custody?
Isaac Wallace should be a waiver.
Wallace. Wallace.
Bailey, Betsy Bailey, we're going to amend the complaint on as well, Your Honor.
Bailey is not in custody.
No, she's not.
Okay, Wallace can be brought up. Let's see, your many the complaints. On the record in the matter of the people of the state of Michigan versus Betsy Sue Bailey, file number 24-02394, counsel appearance.
Good morning, Your Honor. Tessamari Coni appearing on behalf of the people.
Assistant Public Defender Sarah Donnelly on behalf of defendant Betsy Bailey, who is to my right.
Okay, how are you this day? Date set for a preliminary examination, with false report of a felony. How are we proceeding?
Yes, Your Honor. At this time, we have extended the offer to plead guilty to false report of a misdemeanor. That offer was not accepted. We will be amending the complaint to be false report of a misdemeanor.
Your client wants a pretrial?
Yes.
Okay.
October 1st at 10:30.
October 1st at 10:30. Reach your notice to appear. Do you have any questions today, ma'am?
No, no, yeah.
Any additional matters for the record, counsel?
Nothing from the people.
Not from defense.
You're all set. Thank you. Wallace was a waiver and
Yes, Your Honor. We're going to dismiss a few counts on that one, but it should be okay.
then probation.
Yeah, that's fine.
Okay, is counsel here with, Mr. Pendas?
Judge, yep, we're ready to go, Judge.
Okay, on the record in the matter of the people of the state of Michigan versus Nico Pendas, file number is 24-00739, counsel appearance.
Good morning, Your Honor. Case Mark Arian appearing on behalf of the people.
Good morning, Your Honor. Spencer Clayton appearing on behalf of Mr. Pendas, who stands to my right. Your Honor, we do have an interpreter.
Okay, can the interpreter raise your right hand? Do you solemnly swear or affirm to interpret the matter before the court completely and accurately and not divulge confidential communication to help you God?
Yes.
You state your name, first and last, and spell it.
Alma Thorne, ALMATHORNE.
Okay. Today's the date that's set for sentencing. A pre-sentence report with a recommendation. It was prepared on August 28th. Counsel, did you get it?
Your Honor, we did receive a copy of the report. We did go over it together. We do have a correction.
Yes.
I don't know if it's so much of a correction, but as far as his statement to probation, he does not deny that he did approach the victim in this case, did have contact with her. He also was not in his garage, but just to summarize, he's not denying the fact that he did approach her and had contact with her, which is contrary to what his statement was to probation at the time of the pre-sentence report.
He was not in his garage?
He was in his house. His wife was in the garage. The wife came in to the house to tell him that the
Motion.
correct motion light had went off. So there's a translator, obviously, Judge, but that's his version of the events.
Okay, well, I guess the concern that I have is recognizing that we've had some language barrier concerns throughout this case. Is it was his position that this person was on his property?
I don't think so, Judge.
That's what my understanding was. His motion sensors went off and that he was making sure no one was breaking in.
The motion, there's a chicken coop. It's on the property line. I think it went off behind the chicken coop, and there's a field. That was the allegations. It's not disputed that.
Okay, sounds good. Any other updates or changes?
No, Your Honor. The rest of the report is factually accurate.
You can make allocation.
Your Honor, the recommendation here is not for probation. As I made the court aware, I believe the last time we were here, it's his desire to return to Bosnia along with his wife and his daughter, both of whom are here today. The agreement with the people was that they would not object to no upfront jail. Certainly that's not a killer rule, but I would ask the court to just sentence him to his time served. He's currently residing in an apartment approximately 10 miles away from where this took place, his residence. The court's aware this does involve the neighbor. He does not wish to have any contact with her. That's certainly her desire as well, and obviously what is in the best interest of all parties. Judge, I'm simply asking the court to close this matter out, allow him to return to Bosnia. He does have a couple medical procedures that have done before that happens, but that's his desire, and his entire family is going as well.
Does your client wish to make a statement at all?
No, Your Honor.
I've reviewed the pre-sentence report and the recommendation. I've also got here. It's like a letter from David Burke.
That would be his next door neighbor. The sergeant, Lansing Police.
Okay, former officer.
Correct.
I was retired, but I could be wrong.
He is retired.
Okay, sounds good. And it was a character reference. for Mr. Pendas. The court has read that. I won't read it into the record. It speaks favorably of your client. I think there could be concern that the court has, or had, I should say, when reading this report, was that maybe there was an issue of some miscommunication, and that was asserting that he was in there trying to look out for his property, didn't realize what was happening. I don't know that that's the case. It's also not what the factual basis supports. Nonetheless, he did plead no contest. And so we just read the report into the record. I think that, and he has no prior criminal history.
Right.
Wants to return to Bosnia. Served in custody a couple of days on him. I'll give him credit, time served, waive fines and costs. He's all set. That's Isaac Wallace.
Yes,
This is Wallace here.
Okay, very good. On the record in the matter of the people of the state of Michigan versus Isaac Wallace, 24-02094, counsel appearance.
Morning, Your Honor. Case Markarian appearing on behalf of the people.
And Attorney Luke Goodrich from the Public Defender's Office here to represent Mr. Wallace, who's standing to my right.
Okay, Mr. Wallace, I have a preliminary examination for you today on various counts. I think it's 10 counts and a habitual offender, second offense notice. My understanding is that there's going to be an unconditional waiver.
Conditional waiver, Your Honor.
A conditional waiver?
Yes, Your Honor. Conditional waiver is contingent upon we, as the people, will move to dismiss counts 3 through 6 and count 8. That's 5 total counts of R and O that we're dismissing, so long as Mr. Wallace waives.
That is correct.
I'm gonna need you to write that down.
You want me to write that
Oh,
down?
yes. The counts, that is, I just can't.
Oh, okay.
Speaking of plan, Your Honor.
Oh, yeah, that's completely fine. I just need to transfer it. Make sure I do it right.
You want the complaint as well, Your Honor?
No, you can just write it down. Okay, so counts 3 through 6 and count 8 will be dismissed upon waiver.
Correct, Your Honor.
No. That's what you want to do, sir?
Can we approach the file?
Yes, thank you. Okay, let's see. So you understand, Mr. Wiles, that you do have the right to have a preliminary examination in the district court on the felonies that you were charged with. You understand that you have the right to require the prosecution put forth evidence to establish that they have sufficient probable cause that those crimes were committed, and then sufficient probable cause to charge you with those crimes.
Yes, ma'am.
And you wish to voluntarily waive your examination today?
Yes, ma'am.
Is anybody threatening you to do that?
No, ma'am.
Has there been any promises extended to you other than what was placed on the record to get you to want to waive your exam?
No, ma'am.
There was no offer at this time, is that correct?
Correct, Your Honor.
Today is the 11th, 12th. Your bind over day is September 25th. That's the date the circuit court will get the file from the district court. You will not need to appear in circuit court on that date unless for some reason your attorney makes a motion for you to be rearranged, okay?
Yes, ma'am.
Otherwise, your next court date is going to be a pre-trial. Do you have any questions at this time?
No, ma'am.
Okay, bond was set at 100,000 cash surety. Are we addressing bond today?
Your Honor, we do not need to address bond at this time, as he is currently serving a sentence from Judge Schmidt.
Okay, bond will continue. Bond will continue at this time. You're all set.
All right, thanks, man. Have a great day.
Same to you. That's all our jail files. Okay. on the record in the matter of the people of the state of Michigan versus Marcus Jefferson 24-01972. Council appearance.
Morning, Your Honor. Case Mark Hearing appearing on behalf of the people.
And Attorney Luke Goodrich from the Public Defender's Office here to represent Mr. Jefferson, who is standing to my right today.
Okay, Mr. Jefferson, we are here for a weapons carrying concealed preliminary examination, and you're ready to proceed, counsel.
Yes, Your Honor, we are. We do have one preliminary matter beforehand regarding a lab report that was done on this case, Your Honor. I don't think I have an outright stipulation for Mr. Goodrich, but we did discuss, and it's under MCL 766.11B. The lab report is admissible at a preliminary exam. Permission to approach with People's Exhibit number 1.
Permission granted. Any other preliminary matters?
No, Your Honor, at this time, people are ready to proceed.
None from the defense, Your Honor.
Call your witness.
People call Alicia Sorrell to the stand. Yeah, I got her in the conference room. I'll read for you.
You solemnly raise your hand. Do you solemnly swear or affirm the testimony you're going to give is the truth and the whole truth under penalty of perjury?
Yes.
You can have a seat right there, ma'am. So there's a microphone that's in front of you. The lady behind you has to pick up everything that's being stated in the courtroom so that a record can be made. That microphone is what's going to allow her to hear what you're saying, but it doesn't amplify your voice in the courtroom. So your voices need to be loud and clear, okay?
Okay.
All your responses must be verbal. If there's an objection from either side, you'll stop speaking so that I can make a ruling on that objection, and then I have to let you know you can give us that response or not.
Okay.
No head nods or head shakes, otherwise we'll have to ask you if that's a yes or no, okay? Can you state your first and last name and spell both?
It's Alicia Sorrell, A-L-I-S-H-A, last name Sorrell, S-O-R-R-E-L-L.
You can proceed, counsel.
Thank you, Your Honor. Good morning, Alicia.
Morning.
Thank you for hanging out for us here for a little bit. Hopefully we won't take up too much of your day here. What do you do for a living?
I work at a church. You have to say my occupation. I work at a church, and then I literally work between 2 and 3 jobs.
Do you live here in Lansing?
I do.
How long have you lived in Lansing?
My whole life.
Do you know someone by the name of Marcus Jefferson?
Yes.
How do you know that person?
I was dating his cousin.
How long have you known Marcus?
Know him, like I've known him for over 20 years, but I don't know him like that. I just know that's his cousin. To be clear.
Do you know who Marcus Jefferson is? What he looks like?
Yes.
That person that you've named identified as Marcus Jefferson, is he sitting here in court with us today?
Yes.
Could you please point him out and identify him by an article of clothing he's wearing?
Right there in the gray and yellow hoodie.
Your Honor, let the record reflect Ms. Sorrell has identified the defendant.
No objection.
The application is noted.
Alicia, I'm gonna follow through on my promise to not waste your day. We're gonna get right to it.
Mhm.
Do you recall the date of January 1st, 2024?
Yes.
What happened on that date? Why do you remember it?
That day, because I was assaulted by his cousin, he broke my window, smashed my laptop, flipped out at my house, I had to call the police on me. And it was also New Year's, so.
So New Year's, you were assaulted earlier in the day. What
Mhm.
happened after you were assaulted earlier in the day?
Well, after I was assaulted, I called the police and filed the report. And then I did drive over to Marcus's dad's house to verify that Jermain was there, because I assumed that he called them to come and pick him up. So I drove over there and
We talked about somebody named Jermain there for a second. Who's
Mhm.
Jermain?
Jermain was my boyfriend at the time.
Would that be? Who's Jason Haskins? Do you know someone by the name of Jason Haskins?
Oh, Jason is I don't know that that's his real last name, but that's the guy from the store.
The guy from
Or
the
the
store.
guy.
Tell me a little more about that. What do you mean, the guy from the store?
He's just somebody who I was telling what happened to me, and he was upset, so he went back and forth with Marcus a little bit via text message, and I don't think they talked on the phone. I think it was just via text message.
Do you recall what Marcus said? Did you see these text messages?
Objection, hearsay.
There's an objection as to hearsay. You're asking, did she recall what someone said?
What the defendant said, yes, Your Honor.
Your Honor, she just testified that these messages weren't even going to her. She's testifying as to what this Jason Haskins told her was being texted between him and Mr. Jefferson.
I can lay some more foundation if you'd like.
Okay, thank you. Objection sustained.
So let's, just for a moment, let's break this down.
Yeah.
You talked about some text messages sent from the defendant to this person named Jason. Were you actually with Jason when these text messages were being sent? How do you know they exist?
At first, yes, but I ended up going home.
So did
So
you-
that's how I know they exist, because they were in a text now app on my phone. And he was saying things like that we were at the cemetery, just a bunch of lies, like that we were.
Objection. Again, we're getting into these statements. I don't seem clear who they're from at this point.
Can you clarify who these text messages?
Yes, Your Honor. Thank you. Let me just lay a little bit of foundation first, Alicia, okay? So you've mentioned that there were some text messages and that there was a text now app on your phone.
Correct.
Would it be fair to say that this Jason person was texting with the defendant on your phone?
Yeah.
Did you see these text messages?
Yeah.
How do you know that the defendant was the one sending those text messages?
Meaning Marcus.
Yeah.
Because of the stuff he was saying. And they also left a voicemail. Because first it was me arguing back and forth with him, and then the guy started texting him, like just getting him worked up, really. And so yeah, and he left a message. Him and his girlfriend are on a message.
Would that be a voice message?
It was
or-
a voice message where they were talking to Jermain, who was clearly there, asking him like, do I talk to him like that and things like that, and just trying to confirm like, was it me texting or was it the guy texting him?
Are you familiar with what the defendant sounds like, Marcus Jefferson?
Yes.
With that voice that you heard on that voice message before the text that followed, was that Marcus Jefferson?
Yeah, saying that I had a white boyfriend and some other lies.
Well, let's focus on the text messages between Jason and Marcus now. But leave out responses from Jason, because I don't think we're going to be able to get those in.
Yeah.
But what did the defendant say that caused you some concern and made you call police?
Oh, that he was willing to like come up to the, like something about coming up to the store to shoot or fight or something like that. Like that basically he would kill people.
Was it shoot? Was it fight? Was it kill people? Which one was it?
It was both, if I'm not mistaken. It was basically, the text messages were basically him inviting, like, come back over here, come to his house, come back. He wanted them to come to his house.
I'm going to object. She's not stating any statements that were actually in the messages. She's summarizing up and giving summaries of her interpretation of what these are. These are not actually direct statements from my client. So I would ask that these be struck as hearsay at this time.
Sort of respond to them.
Your Honor, I unfortunately don't have the text messages themselves, but she has testified to statements of the defendant after we've laid some pretty good foundation, I think, on the fact that it was the defendant. She knew it was the defendant. These text messages were being exchanged on her phone. In fact, he even sent a voice message with his voice that she knows and she identified prior to these other messages. She's talking about, I can try to narrow this down to the actual date in question, Your Honor, so we can move things along, but I think this all qualifies as admission by a party opponent not hearsay.
Okay, but I think the concern is that she's not making any specific statements. She's generalizing, and I don't know if it's clear that she remembers what the statements are.
Yes, sir. I can ask that question. How about that? Ms. Sorrell, do you remember exactly what these text messages said?
Absolutely not, unless they're in front of me. Of course, I can remember exactly what they said.
That's fair. So what we have so far is that there were some text messages being exchanged between the defendant and a person named Jason on your phone. At some point that day, did you call the police in regards to Jason and this going to the store incident?
I did.
Why did you call the police?
Because he was talking about basically because he was being threatening, he was saying that he was gonna go up there and shoot him or something like that. I knew that Jason probably wasn't gonna actually go to this.
Let me stop you there. Do you know if the defendant has a gun?
Yeah.
How do you know that?
Because he had just pointed it at me about 30 minutes prior.
So prior to this whole text message argument, the defendant had pointed a gun at you.
Correct. He came out.
Do you know what happened with that gun after he pointed it at you?
I did not. I drove away.
Did you see him give it to anyone else?
I did not.
Did you see him throw it anywhere else?
I did not.
Did you ever see that gun outside of his possession?
I did not.
So would it be fair to say that gun, as far as you know, was still in his possession?
When I pulled off, it certainly was still in his hand. Yep.
Now, we've mentioned a store a couple times. Are you familiar with an L&M party store at 1701 West Willow Street?
So yes.
Yes, I'm sorry.
Is that located in Ingham County?
Yes.
Here in Michigan?
Yeah.
Why did you call the police about something that you were worried might happen at that store?
Well, A, because he had just pulled a gun on me, and B, because he was threatening to go up there and shoot Jason. So.
Do you know how soon he was planning to go over there and shoot Jason?
He was ready right away. He wanted them to. I think. Well, no. He thought that I had people with me, and I didn't. My people are the police, so that's who I called. Basically.
Would it be fair to say after you called the police, you're not quite sure what happened or didn't happen at that store?
I went home. I just know that he was going up to the store with the gun for some violence. So I called the police to prevent that from happening with great hopes that they would catch him with the gun.
I have no further questions for this witness. Thank you, Your Honor.
Ms. Sorrell, you stated that you drove over to Mr. Jefferson's place, correct?
So yes.
Yes,
Yes.
I'm sorry.
And that is at 3105 Snow Glen Lane, correct?
I don't know their exact address. That's why I drove over there, really.
All right, would you know that if that is actually in Lansing Township?
The house that I drove to,
Yes. Okay, so that, and you stated that he pointed a gun at you at that place, correct?
Correct. Not at that place. Let's be clear. I was on a public street inside of my vehicle. He stopped my
Okay,
car.
but
Okay.
but that in that vicinity.
Correct. Yes.
And you stated that you saw a gun in his hand?
Yes.
Okay. And that was the only place you saw the gun was in his hand at that time?
Yeah.
And then you don't know what happened after that point?
No.
No further questions, Your Honor.
Any redirect?
Briefly, Your Honor, yes. When, or let me phrase it this way, how long before you called police did you see him with a gun in his possession?
The second time, or the second time I called.
Before you called the police about the party store in Jason, how long beforehand?
Probably between 30 and 40 minutes.
Less than an hour?
Less, I'm pretty sure.
Thank you, Your Honor. I have no further questions.
I think you may be excused, Ms. Sorrell.
Your Honor, at this time, the people would call Officer Jamil Bakri. Thank you. Thank you.
One witness down, one to go. Just one officer, and then we'll be down. How did my other courts?
You solemnly swear or affirm the testimony you're going to give is the truth and the whole truth under penalty of perjury.
Yes, I do.
If you can have a seat. State your first and last name and spell both.
Okay, Jamal Bakri, first name is Jameil, last name is Bakri.
You can proceed.
All right, this time before I proceed, I would just move to admit people's exhibits number 2 through 6 pursuant to stipulation.
No, yeah, no objection.
Just like so a minute.
I'll wait to approach, Your Honor. All right. Officer Bakri, twice in 1 week. Nice to see you again. Thank you for being here and waiting for so long. Are you currently employed?
I am.
Where?
The city of Lansing,
How long have you been employed with the city of Lansing?
just over 5 years.
What's your current rank and assignment?
I'm a police officer and I'm responsible for patrol.
Could you generally describe what patrol duties include?
Yep, so basically just responding to calls for service as they pop up.
Have you ever responded to a call for a service about a carrying concealed weapon
Yes,
or about a threat for a shooting?
yes.
How many times? If you can recall or
It was-
estimate.
it would be hard to estimate. We're pretty busy department.
More than 50?
Uh,
More than 100?
Probably.
Okay. I'm going to take you back to the date of January 1st, 2024. Were you on duty and working in that same rank and assignment you described?
I was.
At around 10 o'clock PM?
Yeah.
At some point, did you receive a call to respond to the location of 1701 West Willow Street?
I did.
What's at that location?
It's a L&M, like corner store.
Why did you respond?
There was a, it's called a threats complaint. And the caller advised that Marcus was on his way to this, that they had received secondhand information that Marcus was on his way to this location to shoot the threat.
Was there any indication of whether or not, or did you have any information of whether or not the suspect was armed?
Outside of them saying that the threat of shooting the friend, there wasn't any additional information as far as firearm information that night.
How long after, if you recall, did it take you to get to that location after dispatch?
I don't know.
Would it be less than 30 minutes?
Yes.
Maybe less than 10 minutes?
Approximately.
Less than 5?
Probably.
Somewhere between 5 and 10 minutes? When you responded at that location at 1701 West Willow, what did you see?
Upon coming into the area, I was driving westbound Willow. The L&M is situated on the south west corner of what would be Comfort and Willow. As I looked down the driveway for to get into L&M is there's 2 driveways. There's one off of Willow and then there's one off of Comfort. And I was driving towards the driveway that was situated on Willow, just west of Comfort. As I looked down Comfort, I could see 2 subjects, both wearing blue, walking towards, walking northbound towards Willow.
two subjects wearing blue. Does that description of subject wearing blue stand out for any reason?
Yes, when we were dispatched to this call, the caller provided dispatch with the information that Marcus was wearing an all blue outfit.
You've said the name Marcus. Did you have the suspect's name before you went over?
I did.
What was his name?
Marcus Jefferson.
Did you have anything that would help you identify that person?
Yeah, they added a photo of his ops to the call.
Do you recognize that person that you identified as Marcus Jefferson here in court today?
I do.
Could you please point him out and identify him by an article of clothing he's wearing?
Yep, he's sitting off my left. He's wearing a cream or gray colored sweatshirt with yellow.
And to be clear, is this the person you eventually made contact with and arrested? Your Honor, please let the record reflect Officer Backery has identified the defendant as the person he made contact with and arrested.
No objection. Your Honor.
Identification's noted.
So you were driving down Comfort and saw two suspects wearing blue.
No, I was driving down, westbound on Willow.
Westbound on Willow saw two suspects wearing blue. What happened next?
So as I'm passing the intersection of Comfort and Willow, while still traveling westbound on Willow, I look southbound towards Comfort, and that's when I see the two subjects walking northbound. They're on the west side of the road. As I'm passing that intersection, one of the subjects stops and then begins walking behind the element, where I know there's not a door back there.
Do you know who that subject that stopped and walked behind the L&M is?
Yes.
Who is that?
Who's later identified as Marcus.
Okay, so we have the defendant stopping and walking behind the L&M store when you approach in your vehicle.
So as I'm passing the intersection. And then the second subject continues walking northbound towards me.
Did you ever make contact?
His voice got a little low.
I'm sorry.
Second subject did what?
Continued walking northbound
Okay.
at that time.
Did you or any other officers ever make contact with that second subject?
Later on.
Now let's get back to the defendant who walked behind the L&M party store. What happened after he walked behind it and that second subject walked away?
So as I was observing that, I was passing the intersection. So I had to turn into the driveway entrance that is situated on Willow to get into the parking lot. And I used that parking lot to go around the building to now go southbound, parallel with Comfort, but through the parking lot of the L&M to get to the backside of that building. At that time, Mr. Jefferson was walking back eastbound, back toward my patrol vehicle from around the corner of behind the building.
Did you at this point initiate contact with him?
I did.
Why is that?
Based off of the call to investigate the allegations that were made in regards to why we were there, and we had also been notified that he had a felony warrant.
Would it be fair to say you were going to arrest him on those warrants at this time?
Yes.
Did you?
Yes.
Did you search him incident to arrest?
Yes.
What did you recover, if anything, when you searched him incident to arrest?
There was nothing.
What, if any, mode of transportation did you know of the defendant having or arriving to the location?
So part of the call when we were dispatched is that the subject may be driving a silver sedan. I did locate car keys in his pocket, and there was a silver sedan parked down the road, the next intersection on Comfort.
Silver sedan parked down the road. Was there not a parking lot at the L&M party store?
There was.
Okay, so he parked down the road away from the place where there was a park.
Objection, calls for speculation.
Do you want to respond to that?
Your Honor, I think this is rationally based on his perceptions. He found the car keys in his pocket. They had an information that the defendant was going to be driving a silver sedan, and then he found him within a couple blocks of it.
Texas assistant.
Did you eventually locate the Camry?
Yes.
How far away was it?
It was approximately 250 feet down or 500 feet down down Comfort. So just south of the element.
Did you recover a firearm on the defendant when you first searched and arrested him?
I did.
What happened after you searched and arrested him?
So upon searching him and arresting him, The warrant itself was not out of our department, it was out of Lansing Township's department. So at that moment in time, I notified Lansing Township that as part of our normal procedure that I had him in custody, and they arrived on scene to take custody of him.
Was a search conducted of the surrounding area at this point?
It was.
What kind of a search?
So basically, it's called canvas searches, where other officers on scene, we pretty much just based off of the facts of the call, as far as that he may be arriving with a firearm to shoot someone, and the fact that his vehicle was parked down the street, and the fact that upon seeing him, he went behind the building and then came back out towards Comfort in a relatively small amount of time. We searched the back area, the back lot of that building to see if we could find a firearm out in the open or in the bush.
Was a firearm found out in the open, just laying in the parking lot or anything like that?
Nope, at that time we searched the ground level and we weren't able to locate anything.
You stated that you searched the ground and you did a canvas. Would it be normal or customary for officers to search the roofs of building during one of these?
Not customary. It has happened in the past. If certain circumstances dictate that we would do that. However, typically we would search the ground level.
At some point, did you go back to conduct a follow-up search?
I did.
Why'd you do that?
So as part of my normal patrol duties, I had to, once Marcus was turned over to Lansing Township, I had to continue responding to calls because, as I said, we're a busy department. As I continued on, and I just continued to think about all the facts and circumstances that were surrounding this call. I recognized that the building's roof was relatively low and that something could have been thrown up there.
Did you go back to search?
I did.
Were you assisted by anyone in your search?
I was.
Who?
So initially, I called for, it's called a start officer. It's a member of our tactical team. And the reason is because their vehicles that they drive are equipped with specialized equipment, one of which is a ladder that would allow us to basically climb the side of the building in order to see the side of the building. After that, the ladder that they had wasn't the sturdiest of ladders. So at that time, we called for LFE so that we could use one of their full metal ladders.
Once you were able to get a ladder sturdy enough and tall enough to reach the roof, what, if anything, did you find?
So from looking at the southeast corner of the building, we could see what looked to be the shape of a small black handgun, approximately in the middle of the building, on the south side near an air vent that was situated there. We then moved to the southwest corner of the building simply because the ground around the building was a lot flatter, which would allow the ladder to be safer to climb. And upon doing that, I was able to get a good look at it and confirm that was a firearm that was on top of the building.
How close was that firearm where it was located on the top of the building to where you had seen the defendant go behind the building earlier?
So when I observed the defendant go behind the building, that was at the southeast corner of the building. This firearm was located approximately right in the middle of between the southeast corner and the southwest corner. So it would, given the time frame in which it took me to turn my vehicle around and get back to the southeast corner of the building and to where I saw Mr. Jefferson coming out from behind the building, it was right in the time frame of what it would take to get to the middle of the building and then get back.
Are you familiar with the term open carry?
Yes.
At any point earlier in the day when you interacted with the defendant, did you see him openly carrying a firearm?
I did not.
Did you observe anything that would indicate he was concealed carrying a firearm?
I didn't observe anything at that time. I can say that I didn't see anything in his hands. He did have a baggier clothing on. And based on the fact that the firearm was thrown on top of the building upon the scene, upon seeing my patrol vehicle, led me to believe that the intent there was to conceal the firearm.
I'm gonna approach you with some photographs. Well, let me ask you this. Did you take photographs that night when you went back for your follow-up search?
I did.
I'm gonna approach you with some photographs here. People stipulated exhibits number 2 through 6. Just flip through those for me. Tell me if you recognize them.
I do.
Permission to approach, Your Honor? Publish, I should say. All right, now we had some photographs there, people's exhibits numbers 2 through 6, the building and then a gun. Is this the same building and gun that you ended up searching and recovering?
Yes.
Did you or did anyone else, to your knowledge, submit a lab report for a DNA analysis of that firearm?
I did not submit the lab report. I believe that detective and CSI did.
Nonetheless, you are aware that a lab report was submitted for a DNA analysis of that firearm?
Yes.
What, if anything, did you observe about that firearm? Was it dusty? Was it weathered?
So the firearm was clear of debris. It didn't appear to have a layer of dust on it or dirt, things that would typically be found on items that had been left outside for a long period of time. On top of that, the firearm itself had a strong odor of marijuana on it that could be smelled even as the firearm was transported in the vehicle. There also appeared to be a long strand of hair stuck in the chamber of the firearm.
Based on your training and experience as an officer, if you can tell us, would that suggest to you that that firearm was recently placed there or had been there a while?
Recently placed there.
Why is that?
Because again, when items, in my experience, when items have been left outside for a longer period of time, they accumulate dust, they accumulate dirt from wind blowing, especially on rooftops where rain and the elements and stuff like that can occur. So seeing that firearm and relatively clean like that led me to believe that that firearm could not be.
Approximately how long after your initial arrest and stop did it take you to go back and conduct this follow-up search?
From the time that I left the scene, the first time after Mr. Jefferson was arrested, it was approximately 2 hours later.
Fair to say you don't know the results of the lab report, if one was done?
I don't.
Thank you, Your Honor. I have no further questions at this time.
Cross-exam.
Officer, when you're driving down Willow Street, did you see Mr. Jefferson carrying a firearm? So not in his hand? You didn't see anything in his hands at that point?
I did.
Did you see anything that appeared to be a bulge in his pocket or something along those lines?
I did not.
Did you see, and you didn't see him get out of that sedan parked down the street?
I did not see him get out of that sedan, but I have stopped Mr. Jefferson in the past with that same plate on a different vehicle.
And he was what, between the sedan and the store when you first see him?
Yes.
All right. So you never saw him carrying a firearm? Correct. You never saw him carrying.
No.
You did initially see 2 subjects walking down the street.
I did.
Was there a time where the 2 of them were out of your view based on you having to turn into the driveway in West Willow?
Yes.
Both of them were out of your view at that point?
Correct. However, the second subject continued walking in my direction. So upon when I came around the building, he was now walking.
So it's fair to say you saw him quicker, but the 2 of them were both out of your sight for a little bit?
Yes.
No further questions, Your Honor. Oh, I'm sorry. I do have one further question. Were you able to get any video or anything like that regarding this location?
I did make contact with the owners for surveillance footage, but the cameras in the back of the building.
Okay, all right. So nothing further, Your Honor.
No redirect, Your Honor.
You, Officer Decker, you can be excused.
Thank you.
Any additional witnesses?
No, Your Honor. People arrested.
This is the defense calling witnesses today.
No, Your Honor.
This is the argument.
Thank you, Your Honor. As Your Honor is well aware, we're here for a preliminary exam. It's a probable cause standard today. Our duty is to prove that a felony was committed, specifically carrying concealed weapon, and that this defendant is the person who did it. Pursuant to criminal jury instruction 11.1, Your Honor, to prove carrying concealed weapon, I only have to prove two elements. Defendant knowingly carried a pistol, that pistol was concealed on or about the person of the defendant. The other necessary requirements for location of 1701 West Willow Street of Lansing, venue, Ingham County, Michigan, date of January 1st, 2024, and the identification of the defendant himself have all been met as well. Admittedly, Your Honor, there is little direct evidence on this case. It is primarily circumstantial. However, I think in the totality of the circumstances, we have more than enough between the two witnesses that were provided to bind over on a probable cause standard for carrying concealed. Regarding the first witness, Alicia Sorrell, she stated that earlier in the day she was assaulted. That assault involved a firearm. The defendant pointed directly at her approximately 30 to 45 minutes before she called police to report that the defendant then was threatening to go to a party store to shoot someone named Jason. After this comment happened, after the firearm was pointed, the defendant, circumstantially, Your Honor, we have proven he immediately went over to that store. She called police and he was there walking to the store by the time police responded about 5-10 minutes later. Your Honor, there is nothing to suggest and no evidence has been presented to prove or disprove that the defendant ever got rid of that handgun until he got to that store, that it was ever out of his possession. There was a 30-minute window where no one else saw anybody other than the defendant with that gun.
Yeah, and I would object to this argument, shifting the burden over to the defense to have to prove something at a preliminary exam, which clearly we don't.
Objections noted. The court's more than well aware of what the burden is.
Yes, Your Honor. Not suggesting that the defense needed to prove anything here today. My point is, there's no evidence to suggest that that handgun ever left the defendant's possession. It was a quick turnaround, 5-10 minute response, and they caught him while he was walking to this store where he had threatened to shoot someone earlier in the day. Then he was walking with his friend, and as Officer Bakri stated, his friend continued to walk down the street while the defendant ducked in behind the party store. Your Honor, you have People's Exhibits number 2 through 6 there. The party store is a very short building. You can duck around it, and I believe we have circumstantially proven through the testimony of Officer Bakri, and directly proven that the defendant did duck around that building and throw a firearm to conceal and hide contraband from police. There was no firearm visibly apparent on him as Officer Bakri approached, and then a firearm that Your Honor has a lab report for was matched to the DNA of the defendant on the trigger of the firearm itself, was found on the building right where he ducked behind. Your Honor, the complaint was a threat of a shooting. The vehicle that the defendant had keys for his pockets with, in his pocket with, was parked a couple blocks away. And then he walked to the store, and circumstantially we have proven he did so with a concealed weapon on him and then threw that weapon onto the building to get rid of it. Officers went back, found the weapon later, and it's got a DNA match. Arrest.
Your Honor. Your Honor, as Mr. McCarrion stated, they have both of these elements, but I would argue that they failed in both of these elements. Well, we heard from Ms. Sorrell that she testified that Mr. Jefferson had a gun in his hand at some point in Lansing Township early on in the situation. She did not see what happened. She immediately called the police, did not see where he went, did not see if he carried it elsewhere, did not see where he went. She never saw him conceal the weapon at any time. And then we have the officer pull up. He again said that he never saw a gun on Mr. Jefferson, either openly carrying, either concealing. There's no evidence. And the prosecutor is required to actually have some affirmative evidence that this act was committed. Guessing that maybe it was him who had a gun. Well, we do have they do have this lab report, which states that he was one of 4 people who had DNA on this gun. It doesn't state when the DNA was put on the gun. I mean, for all we know, this other friend had possession of a gun and tossed it on the roof at some point after
Check your
Mr.
honor,
Jefferson.
mischaracterized the testimony. The other friend never went behind the building.
Well, we don't know. We can only talk about the testimony we have for the court, which is that the defendant, Marcus Jefferson, was seen behind the building. I can't really, there's an infinite amount of possibilities about how many other people could have potentially went behind that building at another time. But that's not information before the court. And if that's argument, and then that's a question for the finder of fact. If maybe someone else went behind it.
Fair enough, Your Honor. I withdraw.
Okay, and all I'm stating is, Your Honor, that they have not proved Mr. Jefferson any more guilty than this other individual who was back that the officer said did get out of his sight for a while, or even if a brief period of time. Without any affirmative evidence that he was carrying a weapon or concealing a weapon, because even if the court believes he did have a weapon, if he had carried the gun in his hand from one place down to the other place, that's not against the law, and toss it on the roof. He's charged with concealing the weapon. And there's just zero evidence of that, Your Honor, for a trial of fact to even consider at this point. So I would ask the court to deny bind over on carrying concealed weapon.
No, Your Honor.
The court is here for the purposes of preliminary examination to decide whether or not there's sufficient probable cause that a crime was committed, and then sufficient probable cause to charge you with the crime. This isn't a trial. They don't have to prove each element beyond a reasonable doubt. They only need more than mere suspicion that this crime occurred. A very low burden. It's a flexible burden. It's based on the circumstances presented today at the examination. I am the sole determiner of the credibility of any of the witnesses, and I'll also weigh the probability of the government's ability to establish guilt at trial. We had testimony from two witnesses today. First, from Alicia Sorrells, testified that on or about January 1st, 2024, that she had been in a dating relationship with someone she described as the defendant's cousin, and that she had been assaulted that day, that she then drove over to the defendant's father's home to confirm that her boyfriend or ex-boyfriend was in that location, and that she said that she saw the defendant point a gun at her. She said she saw the firearm pointing at her 30 to 40 minutes prior to her calling the police and giving a report. We heard testimony then from Officer Jamel Backery from Lansing Police Department, who also testified on or about January 1st, 2024. He reported to the area at or near 1701 West Willow in the city of Lansing, Ingham County, state of Michigan, which makes venue in this court appropriate, in response to a dispatch. The dispatch provided information about a subject by the name of Marcus Jefferson that would be heading in that direction to engage in some level of assaultive action. Officer Backery indicated he reported to that area and he saw two gentlemen in the area located or situated by an L&M party store, that he saw two subjects wearing blue, which was consistent with the dispatch information about what the subject would be wearing. He said he's identified, or he saw the person he identified in the court today as Marcus Jefferson, stop and walk behind the L&M party store. The officer testified that he was also advised that Mr. Jefferson had a felony warrant. It was his intention to take Mr. Jefferson into custody on that warrant, and that the subject may have been driving a silver sedan, that he may be arriving with a firearm to shoot someone. The officer indicated that the silver sedan was spotted not far from the area, that the subject later come from around the building, but later located the car keys on the subject at the time and place of the incident, that he went back to the L&M party store because that roof he recalled being relatively low. I'm thinking that that was an option or opportunity for something to be thrown up there, that he had to engaged the assistance of the fire department, that they returned to search the rooftop of the Ellen Party store, and that there was a firearm observed or located on that roof, that firearm was located maybe in the middle portion of the roof, that he recalled observing the defendant go behind the southeast corner of that building, but that judging on the time frame that he saw the defendant retreat to the other side, that it would be consistent with the firearm being located on the middle of the building. The firearm he testified was clear of any debris, dirt, or dust, indicating to him that it had not been there for a certain time frame, and that the firearm had a strong odor of marijuana, and that there was a long strand of hair located on the firearm. The people admitted exhibits 2 through 6, which indicate the location of 1701 West Willow, Ellen's Party store. There's a picture of the back of that building. It's a relatively smaller building, but based on this picture, it does appear that the roof is low. There is a photograph on the top of the roof with a firearm located there. The People's Exhibit F displays a black Remington pistol on the pistol style firearm on the roof. And Exhibit 6 is a pistol with the clip on it. The officer testified that firearm was sent out for lab results. He was not familiar or knowledgeable as to the results. The people and the defense stipulated to the laboratory report, or at least it was admitted for consistent with the statute, which indicates that the Michigan State Police Forensic Center had tested a weapon on or about February 15, 2024, and that item 1 returned results of DNA for Marcus Jefferson on that firearm. Looks like trigger grip area. The results, Mr. Goodrich argues, also indicates that there are at least 4 contributors or DNA contributions found on this firearm. And so he believes that that's not sufficient for the court to determine that Mr. Jefferson is the person who placed that firearm or that weapon on the roof of 1701 West Willow. Additionally, he argues that there was insufficient evidence as to whether or not Mr. Jefferson carried that weapon in any manner other than potentially carrying it open, based on, I guess, Ms. Sorrell's argument that, or testimony that he pointed a pistol at her. We've gone over the jury instruction. And again, this is largely circumstantial evidence, but the court is to consider the totality of that evidence and taken together, there's more than sufficient probable cause. We have an officer who says that he was questioned by Mr. Markarian as to whether or not he was familiar with concealed versus open carry. The officer testified that he did not see Mr. Jefferson with a firearm when he saw him walking behind the building. He couldn't identify that he saw any other indications that the defendant may have been carrying a weapon, but he didn't see him openly carrying anything, and that he went behind the building. He even testified as to the timing of the defendant being on the southeast corner of the building to make it to the opposite side of the building, and then locating the weapon later on the middle portion of that building, and how that would be consistent with the timing or giving that defendant enough time to place it or throw the firearm up in that area. It's not anything that the court can discredit that although there's 4 contributors, that one of those 4 contributors would be the person who sits in the courtroom today who was seen going behind the building at the date and time of the alleged incident. And also the person that was testified to have pointed a firearm at Mr. Rouse. And also the person that the witness testimony states that threatened to go to this location where the officers located him to shoot or use this firearm or weapon. There was also a connection between the odor that emanated from the firearm, which was, for the officer, an odor of marijuana. I'm gonna put it on the record. I rode up on the elevator with Mr. Jefferson today. The first thing I noticed when he entered the elevator, strong odor of marijuana. The court is satisfied that there's sufficient probable cause as to count 1, weapons carrying concealed. That will be bound over to the circuit court for further prosecution. The bind over date is going to be September 25th, but that's not a date that you need to appear in circuit court. That's the date the circuit court's going to get this file from the district court. They'll then set it for a pre-trial. Unless for some reason Mr. Goodrich believes that you need to be rearranged at circuit court, you will not have to appear on the 25th date, okay? Do you have any questions for the court at this time?
No, I just wanted to get it done and over with.
Okay, and so
Right.
bond was set at 1,000 personal recognizance. That will continue. Here are your exhibits. Any additional matters for the record?
Nothing from the people, thank you.
Nothing from the defense, Your Honor. We would just like to request a transfer.
You can see the snatch for that. Okay, ready to go?
Yes, Your Honor.
On the record in the matter of the people of the state of Michigan versus Eric Mass, file number 24-02547, council appearance.
Good morning, Your Honor. Case Markarian, I'm appearing on behalf of the people.
Thank you, Your Honor, and good afternoon. Jared Austin appearing on behalf of Mr. Mask. He stands present to my right.
Okay, today's the date that's scheduled for preliminary examination, and this is for carrying concealed weapons. Controlled substance, maintaining a drug house, and firearms or firearms possession by prohibited person, that is. Are we ready to proceed on these?
Yes, Your Honor.
Any preliminary matters?
Some stipulated exhibits, Your Honor. Exhibits number 1 through 14, Your Honor. Show approach.
Yes. 14, okay.
A lot, I know.
Any other preliminary matters?
Number 1 there is the copy of a certified conviction for all the PIP charges, Your Honor.
Okay. Any other matters for the people?
No, Your Honor. Please proceed.
Anything from you, Mr. I always do that, Mr. Austin.
You're not the only one. I would just ask for an order of sequestration.
Didn't help that he was the last person and now you just switched it out on me. Nonetheless, sequestration is gonna be ordered. You can call your first witness.
You can call Officer Stephanie Myers. Stacy Myers, excuse me.
You solemnly swear or affirm the testimony you're going to give us the truth and the whole truth under penalty of perjury.
I do.
Thank you. You can have a seat. State your first and last name, spell both.
Stacy Myers, Stacy, STACEYMEYERS.
Surprised you testified in court before?
Yes.
Council, you can proceed.
Thank you and good afternoon now, Officer Myers. Thank you for being here. Are you currently employed?
I am.
Where?
Lansing Police Department.
How long have you been employed with the Lansing Police Department?
Approximately 8 years.
What is your current rank and assignment?
I currently work in the Special Operations Division, the drug unit, and
I assume, but I will ask, is there any sort of specialized training or education you have to go through to become a detective like that?
I received general training in the unit.
I'm going to take you back to the date of August 27th, 2024. Were you working and employed in that same rank and assignment on that date?
I was.
Did you participate in a raid of a home located at 909 East Kalamazoo Street, Lansing?
I did.
Is that located here in Ingham County, Michigan?
Yes, sir.
Can you tell us what you did to assist in the search raid?
I assisted in the searching of the residence.
So you showed up after the raid had already been done.
Yes.
What areas of the home did you search?
I searched the kitchen, the bathroom area, and the downstairs.
What item?
I'm sorry, you said the downstairs?
Downstairs basement.
Basement.
What items, if anything, of importance did you find or stuck out?
I found 2 scales, digital scales that were located in the cupboard in the kitchen by the sink.
Did you do anything with those scales?
I did.
What did you do?
I performed a NARC ID cocaine swipe test.
What is a cocaine ID swipe test?
Basically, it looks like a wipe in a package. We open the package, it's completely white. We wipe the scale where there's residue along the scale, and if there's any presence of cocaine, then it'll turn blue. As I conducted that test, it turned blue.
Do you wear gloves when you do this?
Yes, we change our gloves out between every single item that we test.
What were the results of the NARC swipes on the 2 scales you found in the kitchen?
Positive for the presence of cocaine.
Now, can those swipes tell us exactly like a lab code, what substance or anything like that, or how accurate are they? Maybe that's a better
No,
way.
I mean, it just it tells that there was at some point in time cocaine on that scale.
Okay. Based on your training and experience, would a cocaine swipe be positive if it was weighed in some sort of a bag or other substance, or does it have to be directly on the scale?
No, it can turn positive if you're testing a baggie and things of that nature.
Did you eventually, so you got cocaine swipes positive from scales for cocaine. Did you eventually find any cocaine or other drugs throughout the house?
I did not, other people did.
Did you swipe both scales individually with a different swipe or just one?
I swiped them individually with a different ID swipe.
What were the results of both of those tests?
Both of them were positive.
Would it be fair to say that mostly what you did was swipe the scales and come back with the test that day?
Yes,
Would it be, do you know if there was anyone else working?
that was working there.
Yeah, and
Yes.
searching the home?
Yes,
Would they be better to ask about whatever else was found and located in the home?
yes, sir.
Did I leave anything out that you think the court should know about what you did that day?
No.
Thank you, Your Honor. No further questions.
Thank you. Good afternoon.
Good afternoon.
And you have no way of knowing how long those 2 scales were there, is that correct?
Correct.
And you have no way of knowing who placed those 2 scales there, is that correct?
Yes,
And the residue that you're talking about that was recovered, that's not an amount that can be quantified in any type of way, is that correct?
yes.
And with your training, knowledge, and experience, you wouldn't be able to tell us how long that residue had been on there, is that correct?
No,
You said you were there assisting in the search or the raid of the house, is that correct?
yes, sir.
And what was the reason for that? Was that because there was a search warrant or some other reason?
There's a search warrant for the residence.
Thank you, Your Honor. That's all the questions I have.
Yes, Your Honor, briefly. Officer Myers, did you also perform a TrueNarc test of some cocaine itself, some crack cocaine?
I did.
What was the result of that?
That came back positive for cocaine base.
Do you recall how much weight there was? Did you weigh it?
I did.
Do you recall how much it was?
Without looking at the report, I'd say, I think it was 9.89 grams. Somewhere generally.
Would 9.86 sound correct?
Yes,
And how does a TrueNarc work? Do you test it beforehand to make sure it's working? Can you just explain the process?
yes. Before we test anything, we do check it to make sure that it's functioning correctly. And then once it's tested, we do another self-test that checks the functionality of the machine as well.
What were the results of this test for that 9.86 grams of crack cocaine you found?
That it was operational.
And what were the results on whether or not it was positive for cocaine?
We came back positive for cocaine dose.
And you have no further questions.
Thank you. Officer Myers, you can be excused. Actually, and let me advise you, there is a sequestration order, so you're not to discuss your testimony with any other witness.
Okay.
You can call your next witness.
Yes, Your Honor, the people call Sergeant Kevin Schlegel to this thing. Your Honor, permission to approach and retrieve some of the exhibits.
Absolutely.
Thank you.
You probably need to hold on them, all of them, actually.
Okay.
Just
Can
publish
do.
them later.
Thank you, Judge.
You solemnly swear or affirm the testimony you're going to give is the truth and the whole truth under penalty of perjury.
Nice one.
Thank you. State your first and last name, spell both.
Kevin Schlegel, KEVIN SCHLAGEL.
Counsel, you can proceed.
Thank you, Your Honor. Good afternoon, Sergeant Schlegel. Thank you for being with us for as long as you have. Are you currently employed?
I am City of Lansing Police Department,
How long have you been employed with the Lansing Police Department?
20 years.
What is your current rank and assignment?
I'm a sergeant of the Special Operations Section of the Lansing Police Department.
How does someone become a sergeant of a special operations? Do you get some additional training or something like that?
It's one of the positions selected by the chief or through seniority based, special collective bargaining agreement.
Would what can you generally describe your duties as a sergeant in your rank and assignment?
So my job is to supervise the daily operations of the members of the Special Operations Section. Our duties include narcotics investigations, prostitution, and other vice crimes.
So you've talked about the Special Operations Section.
Right.
Would you be okay if I call that SOS for short?
Yes.
So you're the sergeant for SOS.
Correct.
What does SOS do?
Again, SOS is a specialized unit. Our focus is to investigate narcotics distribution, prostitution, gambling establishments, and liquor violations.
Does SOS sometimes conduct raids of homes pursuant to search warrants?
Correct.
Were you employed in that same capacity on August 27th of 2024?
Yes.
On that date and time, did you assist or participate in a raid at the location of 909 East Kalamazoo?
Yes, I was the supervisor in charge of the operation.
What happened? What was the purpose of the search? Just walk me through it a little bit.
Officer Booth, member of the Special Operations Section, and supervised obtained a search warrant for that residence based on a narcotics investigation. Prior to the operation, we conducted a joint briefing with the Special Tactics and Rescue Team, whose primary job was to execute the warrant by making entry into the residence and securing the occupants of the residence. After that, we conducted our narcotics investigation.
Where do you fall into this situation? Are you the person up front holding the shield that I saw, or who are you?
No, that team, not anymore. That team is supervised by other sergeants. They are a dedicated team just to simply go in and secure the residence, make sure that people are secured safely. And then after that, once that residence is secured, then members of SOS go and actually conduct the search and other operations and investigation.
Did you conduct a search of the home?
I did.
Did other officers on the SOS team conduct a search of the home?
They did.
Would it be fair to say that most, if not all of that evidence was eventually turned over to you and or Officer Booth?
It was turned over to Officer Booth. Yes.
Okay, so I'll turn it over to Officer Booth.
Correct, on scene.
What areas of the home did you participate in? Well, let me ask you this way. I'm going to approach you with some exhibits that have been admitted. I'll have you flip through them. Just tell me if you recognize all of those. People's exhibits number 3 through 14.
Yes, I took this picture, exhibit 3, that was located in the south bedroom. Picture of the closet, that is the silver box that contained 15 stacks individually wrapped of $1 bills. Exhibit 4 is a picture of the same closet, south bedroom. It's a little dark, however, in the corner of that closet was a shotgun that I also turned over to Officer Booth. Exhibit 5, I'm not 100% sure on. I did not take that photograph. That was, stand by one second. Officer Zuber took that photograph when I reviewed the report. That is a safe that he located in the northwest bedroom. The 6 is a picture of the contents of that safe to include a revolver and money, cell phone. The 7, again, I believe that was taken by Officer Zuber in the northwest bedroom. Picture of another handgun that was located. Oh, did you hear that? I'm not sure on exhibit 7.
It's okay if you don't recognize something, that's fine.
Exhibit 8, I know that was a handgun seized from the residence. I'm not specifically sure where. Picture of the same handgun. Exhibit 10, yeah, 10, exhibit 10. That is a picture I took of at the northeast corner outside the residence, between the corner of the residence and the detached garage. Officers on perimeters observed when I talked to them, an unknown person throwing an object out of that window. I also observed the second floor northeast bedroom window was open and appeared slightly damaged. Not sure on this picture. Looks like wrapping. Been wrapping. I'm not 100% sure on the 12, the 13. Unaware. Exhibit 14 is a picture I took of the northeast bedroom. At first, I turned those pills over to the pink pills. I turned over to Officer Booth, who determined they were Benadryl. No evidentiary value there. And then also you can see the picture of the window that appears to be open with the screen slightly damaged.
Commissioner reports the witness, Your Honor?
Yes.
Let's start with exhibit number 4 here, the shotgun. Who recovered this?
I did.
Did you have any information on whether or not the suspect whose home it was that you were investigating was prohibited to have firearms?
Officer Booth, during part of the briefing, indicated the defendant was a prohibited person because of criminal convictions.
Would that maybe be a better question to ask Officer Booth about?
Yes.
Regarding what you did in the home, could you please summarize what you found?
Found in the home, I found the shotgun in the closet, or south bedroom closet. I also found the silver box, if you will, that contained what appeared to be a large amount of money. It ended up being 15 bindles of $1 bills, approximately $1,300, something like that. I found a telephone and $10 bill in the living room table also.
Based on your training and experience as a sergeant, is there any reason why guns, money, and drugs might be found in the same home?
So typically,
I'm just gonna object to that. I think we lack a foundation at this point
As to
the officer's ability to answer that question without being speculative. I think they would need to lay more foundation as to particularly what in his background, training, knowledge, and experience would lead him to draw those conclusions.
Can you lay some further foundation?
Yes, Your Honor, absolutely. How long again have you been on the Lansing Police Department?
20 years with Lansing Police Department, 7 years prior experience.
How many drug cases have you worked?
I was previously on the tactical team, served numerous over 100 warrants, assisting special operations division, entering into what common term of drug houses are to help secure those residents. Prior to that, uniform patrol, I specifically patrolled the area of Kalamazoo Street, which is a high density of drug houses in that area. Responded to hundreds and hundreds of calls inside drug houses. I have an 8-week investigative course. A week of that focusing on narcotics investigations. And I've been a supervisor for 13 years.
How many of those raids have you participated in on drug houses that resulted in drugs, guns, and money being found in the same house?
In the same house, many, I don't have a number.
More than 50?
Well over.
More than 100?
Yeah, pushing that.
Based on your training and experience then, do you know any reason why this particular house located on that high density Kalamazoo area you talked about would have drugs, gun, and money all in the same house?
So typically through surveillance and other investigative techniques, what we find is people go to a centralized location, purchase narcotics. When they purchase narcotics, obviously the person inside dealing with narcotics accepts the money and maintains the product and the money inside the residence. Many of the drug houses that we come across have firearms inside the house in order to protect the product and the money sold within the house.
Did you find any ammunition at this house as well?
I found a case of birdshot for a 12 gauge shotgun. And I also found, I believe, 2 boxes of slug 20 gauge ammunition.
Would those all be ammunition that could be used with a shot?
With that particular shotgun?
Yeah.
The 2 boxes of slugs are chambered for a 20 gauge, which would not fire inside that firearm. The case of birdshot would fire inside that firearm.
Nonetheless, would those boxes of slugs, how many in total do you recall? How many rounds?
2 boxes. I did not open them, but typically they come in boxes of 5.
Would it be fair to say that those could be used and fired through a shotgun of the right
shotgun? Yes.
12 gauge.
Yeah. Not 12 gauge.
12 gauge?
Not a 12 gauge.
Not a 12
Not a 12 gauge.
Regarding the photo of the baggie outside on the ground, People's Exhibit number 10, tell us a little bit about that.
Can I review it, please?
Yes. How did you go about recovering this? What is it? If you know anything about it.
So we had standard operating procedure is when the tactical team initiates action at the house, they do their knock and announce and make entry. We have what's called containment officers on the outside to prevent people from fleeing from the residence and also keep an eye on the windows in case there is discarded evidence. I was notified by Officer Miller and Officer Jenks that a subject had thrown something, although they could not identify him because of the darkness, who it was, that there was evidence discarded outside. This evidence was located on the ground. I simply took a picture of it. I believe it was Officer Miller, turned it over to Officer Booth on scene. I did not highly inspect it.
Fair enough. Do you have any way of knowing whose shotgun you found?
Whose shotgun I found?
Yeah.
No, shotguns are not typically registered unless we do an ATF e-trace on it, which we have not done at that point. The e-trace would determine who the owner of it is or who purchased it. However, shotguns can be sold without, the buyer can sell it to another person without any documentation. So,
are you familiar with a person by the name of Eric Mask?
Eric Mask is the defendant sitting right here.
Your Honor, please let the record reflect Sergeant Slagle is identified.
Any objection?
No objection.
Noted.
How do you know Eric Mask?
Eric Mask was present during the search warrant we conducted.
Do you know who the main suspect you were conducting the search warrant for was?
Yes, Officer Booth during the briefing identified Mr. Mask as the primary suspect.
Would it be better to ask Officer Booth about how we went about finding residency or documentation in the house?
Yes.
Would it be better to ask Officer Booth about how we know who possessed what in that house?
Yes.
Who, if anyone else, was present when you searched?
Officer Myers was
in terms of non-officers.
Oh, I'm sorry. There was a female present in the house. However, I did not have any report.
Anyone else?
There was a child that was that START members had contact with at the door. That child was immediately taken out of the residence and placed in patrol car just for safety issues. A brother of Mr. Mask showed up later on scene, and that child was turned over to the brother.
One moment, Your Honor. Thank you, Your Honor. I have no further questions for this witness at this time.
Cross-examination.
Good afternoon, Sergeant.
All right, sir.
Well, thank you. And you know who the owner of this particular house was we're talking about?
The owner of it?
Yes.
During the review of the report, I know we have proof of residency for Mr. Mass. There was also during the briefing I believe, mother that we thought would be there, but she was not. I did not run the residency check on the house.
So you don't know if Mr. Mask owned the house or somebody else did?
I don't know if it's a rental property or if he is the owner of it.
Okay. And this female that you were talking about was present. Did you speak with her, have any interaction with this person?
I had very minor interaction with it.
Was this an adult?
Adult female, yes.
And you were talking about, through your training, knowledge, and experience of various drug cases, various drug houses, and so forth, the significance of firearms and cash being found in such houses. You recall that?
Yes.
And it's true, people could have, and people do have firearms in their house for reasons other than drugs or illegal activities. Is that correct?
100%. Yes.
Likewise, with cash, there are other reasons other than drugs or illegal activity for why some people would have cash in their house. Is that correct?
Yes.
And just because someone has cash or firearms in their house in and of itself doesn't mean that they're running a drug house or some type of illegal operation. Is that true?
That'd be true. Without the combination of the drugs, yes.
Thank you, Your Honor. I believe that's all the questions I have for the sergeant.
Okay. Redirect.
No, Your Honor. Thank you.
Thank you, Sergeant. There is a sequestration order, so you're not to discuss any portion of your testimony with any other witness.
Yes, ma'am.
Thank you. You can call your next witness.
Yes, Your Honor. People call Officer Adam Booth.
You solemnly swear or affirm the testimony you're going to give is the truth and the whole truth under the penalty of perjury.
Yes, sir.
Thank you. You can have a seat. Can you state your first and last name and then spell both?
Adam Booth, ADAMBOOTH.
You can proceed, Counsel.
Thank you, Your Honor. Officer Booth, thank you for being here. Good afternoon now at this point. Are you currently employed?
Yes, I am.
Where?
City of Lansing Police Department.
How long have you been employed at the City of Lansing Police Department?
10 years.
What is your current rank and assignment?
Current role is I work in the special operations section, which specializes in narcotics violations.
What exactly does would you be fine with me calling that SOS for short?
Yes, that's fine.
What does SOS do?
So we investigate controlled substance violations within the city of Lansing and also assist our violent crime team with firearm violations in the city.
Would it be a normal course of your duties to assist in searching a home after a drug raid?
Yes.
How many of those have you participated?
I would say close to 100.
Did you have any additional training or experience to get on SOS?
Yes, I went through a narcotics school, a week-long narcotics school in the city of Flint. And I also went through a Michigan State Police surveillance school for a week.
Were you employed in that same capacity on August 27th of 2024?
Yes, I was.
Leading up to August 27th of 2004, and then on that day, did you do some work involving a drug raid at the location of 909 East Kalamazoo Street?
Yes, I did.
Let's back up a little and start about how a drug raid happens. What's the process? Do you have to get a search warrant?
So we basically obtain targets that we either gather information on or somehow we receive a tip on a house or a subject that is dealing narcotics or something along that nature. And then we open an investigation into that person. So that can consist of surveillance, it can consist of controlled buys, it can consist of a lot of different things. So we identify that person, we basically work on that investigation to obtain a search warrant for either their address or whatever have you.
Do you recall if you obtained a search warrant for 909 East Kalamazoo Street?
Yes, I did.
What information, if you can tell us, did you have that supported that search warrant?
We had information that there was drug trafficking at that specific location. And we followed up and obtained a search warrant for those facts.
Can you tell me what kind of information you had or how you learned it?
So I received confirmation from a confidential source that was able to purchase narcotics from that location.
Your Honor, I'm going to object to hearsay unless it's not being offered for the truth, but merely to explain the effect it had on the officers, the listener of this information.
So it's being offered for you.
Object.
So after you received some information about a tip, did you receive any information by someone who operates under the street name of Jim Shoes?
Yes.
Do you know who that person identified as Jim Shoes was?
This person was ultimately identified as Eric Lee Mask.
Do you see Eric Lee Mask in this courtroom here today?
Yes, I do.
Could you please point him out and identify him by an article of clothing?
Yes, gentleman sitting over here with the orange shirt on.
So we had a tip about someone named Jim Shoes that you learned to be Eric Lee Mask. What do you do after that?
So after that, we conduct surveillance on the location or where they do most of their activity, corroborate that information, and ultimately, throughout the investigation, attempt to obtain a search warrant for where they reside.
Did you attempt to obtain a search warrant for 909 East Kalamazoo in this case?
Yes, I did.
Did you obtain a search warrant?
Yes, I did.
Who authorized that search warrant?
Judge Simmons.
Let's move on to the actual raid itself now that I think we've covered. Well, prior to going there, did you have any information about who might be in that house, who owned that house?
I believe the information that we had at the time, it was a rental, if I'm not mistaken. And during surveillance, we have seen him come out in and out of that house on multiple different occasions for an extended period. I think several months. So we were under the impression that he had established residency there and that was his primary residence.
And when you talk about he, are you referring to the defendant, Eric Mask?
Yes, I am.
So what happens when you go to the home? Is there a raid to secure first, then you search after?
Yeah, so we, on these, we activate the tactical team. They affect the actual raid itself and securing the residence and securing the subject inside. And then the special operations team will follow behind with the evidence kits and
we take photographs and process everything inside once it's being safe for us.
So let's start at, how did we identify whose home this is?
That was we typically do that during the search. We find items throughout the house that lead us to believe who's staying there. And specifically, we look for residency documentation, who's getting mail at that address.
Did you find any mail at this address?
Yes, sir.
Who was it for?
Eric Lima.
Was it one piece of mail? Was it a lot of mail?
From what I found, I assisted in searching the kitchen. I located a yellow folder that contained a lot of paperwork in it. Upon opening it, I noticed there were several documents addressed to him at that address, the defendant, and those were photographed and attached to the report.
We had several documents, to be clear, addressed to Eric Mass at 909 Kalamazoo.
Correct.
Did you find any documents that had anyone else's name on them with that address?
Not that I recall.
Did you have any information prior to your arrival there that anyone else lived in that house?
We didn't have that person identified at the time. There was a black Jeep in the driveway that registered to a female, but we didn't have confirmation that they were either living there.
Upon arrival and search, did you find a female or anyone other than the defendant?
Yes, there was a female inside.
What about anyone else?
I think there was a child as well.
Do you have any information based on your investigation here if that female lived at that house?
No.
Did you have any information from that female, or did an officer take a statement from that female?
I believe so, yes.
Did that female at any point say she lived there?
I would object, I would call Pearson.
Your Honor, this goes towards MRE. Your Honor, this falls under the exception to hearsay for preliminary exams to establish property and ownership. I can't find the roll number off the top of my head right now, but it was 1101, Your Honor. For property and ownership, all of this testimony is going directly towards that.
Objections overruled.
Thank you. Did someone take a statement from that female?
Yes.
Did she say anything about whether or not she lived there or owned anything in that house?
Not sure what was said during the interview, but she advised me as we were wrapping up and getting ready to leave that she was only grabbing a few things and leaving because that was not her residence.
Did she claim ownership of any of the guns, drugs, money, anything like that that was found in the house?
No, none of those items.
Did she state that she in fact did not possess or own any of those?
She did not advise me that she possessed or owned any of those items.
So we have the female, the child, and the defendant. The female telling you she didn't possess or own anything in that house.
Correct.
What did you do after finding those residency documents?
Typically, we photograph them where they're found, and then we seize some of them as evidence.
I'm going to approach you with some photographs here. People's exhibit number 3 through 14. Flip through all of those real quick and then tell me if you recognize them when you're done. You recognize all of those?
Yes, I do.
Would it be fair to say that in your role in this investigation and this raid, all of the evidence was ultimately turned over to you that was found on scene while you were at scene?
Yes, as the case agent, we have a giant evidence box that we typically operate out of at the target location.
Anybody that locates a piece of evidence will photograph it and then turn it over.
Now I'm gonna start pretty general here and try to funnel down to what exactly was found. Were drugs found?
Yes.
Were guns found?
Yes.
Was money found?
Yes.
Start with the drugs. What types of drugs and how much?
I believe there was a plastic baggie located with crack cocaine inside of it. It was over 9 grams in total. There was a bag that was located that contained over 1 gram of heroin fentanyl compound. And then there was another small bag that contained some pills that appeared to be either ecstasy or MDMA of some sort.
Do you know, let's start with the cocaine. Do you know if any tests were performed on scene to verify that?
Yes, I conducted one of the tests just to ensure that that was a substance that was located with a true narc device.
Was it true narc positive?
Yes, it was positive for cocaine.
Regarding the suspected fentanyl heroin compound and the suspected ecstasy or MDMA, do you know if a lab report was submitted on those?
Yes, typically when we seize those substances at street level, we send them off to the Michigan State Police Lab because they are mixed with so many different substances at this point. And then those are submitted to the lab. Ultimately, the heroin tested positive for fentanyl, and the pills were positive for methamphetamine.
Have you seen the lab report?
Yes, I have.
Are you familiar with it?
Yes.
Would you recognize it if I approached you with it?
Yes, I would.
You've already testified, but just to be clear, can you tell us what People's Exhibit number 2 there, the lab report says, and the results of what you sent to the lab?
Yes. So item number 1 is a plastic bag with some brown chunky material. That was 1.05 grams of fentanyl, positive schedule 2. Item number 2, empty plastic bag. It was not analyzed, but also contained 7 pink tablets and 1 yellow tablet that was positive for methamphetamine.
Now, if you wouldn't mind, just set that lab report right in front of you and flip through those photographs there that I gave you. And can you identify which photographs those compounds that you had tested are in? If I missed a photo, you can definitely tell me.
Yeah, there might be. So this is a photo that was taken outside where the fentanyl was seized. And then I think the one that we're missing is the bag of the
Exhibit number 14.
Yeah, that's number 14. This was the allergy medication.
So that's not
This
the
is
pills
not
we're talking
correct.
about. So some different pills were tested and sent to the lab.
Correct.
And what did those come back positive for?
Those were the pills that were positive for methamphetamine.
Do you recall how many pills there were?
There were 8 total.
What the weight is?
There were 8 total. It was about 3.5 grams. I think a little over 3.5 grams of total weight of pills.
Would it refresh your memory if I approach you with a copy of your report?
Yes.
Permission to approach the witness room. Just look at that report there, and when you remember or your memory has been refreshed on how much of each drug, please look up it.
Yes, the pills were 3.75 grams that were sent to the lab.
How much cocaine was it?
9.86 grams.
How about the fentanyl, suspected fentanyl compound?
1.01.
Approaching the witness, Your Honor. Take a copy of that. Do you have any information? Well, let me ask it this way. Did the defendant give a statement to police?
believe he gave a statement to Officer Zuber that conducted the interviews at the scene.
Do you recall, as the officer in charge of the investigation, whether or not the defendant admitted to knowing drugs were inside his house?
Your Honor, I'm going to object to lack of foundation at this point. I don't know if this is something that the officer observed and heard, or if this is something that he's repeating from what another officer told.
Can you clarify?
Yes, sir. Is this something you observed or heard? Is this something you reviewed in a report? How did you know that the defendant gave a statement on scene that day?
I did not observe the interview take place. It generally happens in a different room. But I believe Officer Zuber interviewed the defendant, and he admitted.
Your Honor, I'm going to object that he's not repeating something that he's not telling us something that he observed based on his personal knowledge. He's repeating what another officer may have told him. So I think that's inadmissible hearsay.
Do you want to respond?
Again, Your Honor, I think it goes to the exception showing possession and ownership at a preliminary examination. My only question was whether the defendant admitted to knowing there was or that he possessed drugs in the house.
How could you testify to that?
I can call Officer Zuber back here. It's fine.
Sounds good. The objection sustained.
We've talked about the drugs, we've covered all that. Let's talk about the guns now. How many, if any, guns were found in the house?
There were 3 firearms located in the house.
Do you know what kind?
There was a 38 caliber handgun, there was a 380 caliber handgun, and a 12 gauge shotgun.
Let's start with the 12 gauge shotgun. You know where this was located?
I do not. It was turned over to me.
Do you see it in any of those photographs there in front of you? If not, that's fine.
I don't think so.
How about that 380 handgun?
Yeah, that was recovered in safe that was in one bedroom.
You know what else was in that safe, if anything?
It appears that there is cash along with the cell phone.
Is that cash? Do you recall if it was all the same denomination, if it was mixed?
I believe that there were mixed denominations.
Regarding the 38 caliber, I think you called it a handgun. Could it have been a revolver?
Yes.
Okay, do you see that in any of the photos there?
Yes.
What else, if anything, do you see? Where was it located?
You're referring to number 6 here. That was the one that was in the safe with the cell phone and the money.
Do you have any information on whether or not Eric Mask was prohibited to be in possession of firearms and or drugs?
Yes, we did have prior information on that. We run the 103 check previously, and he had that felony conviction on his record, I believe, too.
Recall if any ammunition was found in the house?
Yes, there was.
How much and where? And if you need me to approach you with a copy of your report to refresh your memory, I can do that as well.
I believe there were 12 gauge shotgun shells that were located. There was a box of 250 along with 2 smaller boxes of 20 gauge shells.
So 2 boxes of shells.
Yes.
And then what other ammo again did you say?
There was basically a box of 250 12 gauge shells. And then there was another 2 boxes of, I believe, 5. So 10 total 20 gauge shells that were found in the same location.
What about any ammunition for handguns?
I believe that there was some located, but I can't recall exactly where.
Would it refresh your memory if I approach you with a copy of your report?
Yes.
Permission to approach the witness room. Review your report for me there and look up at me when you've identified any handgun ammunition or when your memory's been refreshed. Excuse me. Has your memory been refreshed?
Yes.
What, if any, let me approach and retrieve the report. What, if any, other ammunition aside from the shotgun shells was recovered in the house?
So there were 38 caliber and 380 caliber ammunition located in the northwest edge of upstairs of the house.
Do you know how much?
I believe 2 boxes.
How much comes in a box generally? Do you know?
Anywhere from 25 to 50 usually.
So we've got 2 boxes of slugs, a box of 380 and a box of 38.
Correct.
Do you have any, or do you know where they made contact with the defendant inside this house? Where they initially made contact?
I believe from what I reviewed, he was located upstairs.
He's located when? Where?
Upstairs of the residence, on the 2nd floor.
Would that be the same floor that all of these items were found on?
Yes.
Just in case I missed it, Officer Booth, your name identified someone as Eric Mask earlier. Could you identify him in the courtroom by an article of clothing he's wearing?
Yes, he's the gentleman wearing the orange boxer shirt.
Record reflect Officer Booth has identified the.
Any objection to identification?
Without objection.
Identification started.
Thank you, Your Honor. I have no further questions for this witness.
Thank you, Your Honor. Good afternoon, officer.
Good afternoon.
And the different controlled substances that you were talking about, are those items that you discovered or another officer discovered or a combination?
So those items are items that other officers discovered inside the room.
And you were talking about the baggie of cocaine that was a little over 9 grams, is that correct?
Correct.
That was in one baggie, is that correct?
Correct.
And the other baggie that was determined to contain fentanyl, that contained just barely over 1 gram, is that correct?
Correct.
And the bag of pills that were determined to be methamphetamine, that was in just one baggie, is that correct?
Correct.
That was approximately 7 or 8 pills, is that right?
Yes.
Thank you, Your Honor, that's all the questions I had.
Yes, Your Honor, briefly. You were asked about baggies on cross-examination. Did you find any other baggies around the home?
Yes, we found some plastic sandwich baggies inside the kitchen. They were located in a cupboard that was up near the stove.
Based on your training and experience that you've outlined for us with SOS, what does that suggest to you, all these different baggies around the house?
Your Honor, I'm going to object. I think it's a lack of foundation for the officer to testify that. I think would be inspection.
You want to respond?
I think we've laid plenty of foundation at the start of the direct examination about his training, his experience, all the classes, how he got to this rank. I think he's more than capable to testify why there's a bunch of individual baggies empty around the house.
Well, I think he can testify as to his training and experience might cause him to believe that indicates.
Yes.
Whether or not that's what the baggies were, it's a question of fact. Put your objections overruled.
Based on your training and experience, what do having all of these baggies in this house with all the other items that were found, what does that suggest to you?
So when you see a plastic baggie, that's normal. But what makes it not normal from my training experience is when you have corners ripped out of them. That's kind of where drugs are packaged in the corner of a plastic baggie, and then it is tied off and used your mouth, typically a half gram per gram at a time. When you see piles of these in the trash, and you see piles of these in the kitchen, outside of this cardboard container that it comes from the store, that leads me to believe that these baggies are used for packaging and distributing control substances.
Do you see any of those baggies in the photographs you have in front of you?
Yes, I do.
Just so I'm clear, the baggies that you're saying you saw had the corners cut off or ripped out, you're saying?
Yes, there
Oh,
were
okay.
several that actually had the corners ripped out of them.
Okay.
From the photo and people exhibit number 13. Bags that were shoved into the cupboard.
You recall approximately how many baggies? More than 20?
Yes.
More than 30?
I would say between 20 and 30.
Thank you, Your Honor. I have no further questions. Wish to approach the witness or retrieve the exhibits.
Absolutely, and just for the record, you don't need to ask for permission to approach the witness. You're almost there anyways.
Yes, Your Honor. Just trying to be too formal.
Maybe in the new courtroom, but in this one, it's not necessary.
Yes, ma'am.
Okay, officer, you may be excused. There is a sequestration order. That means you're not at liberty to discuss your testimony with any other witness.
Thank you, Your Honor.
Thank you for the rest. Any other witnesses?
Yes, Your Honor. There should be Officer Zuber on the way. I believe Mr. Martinez has stepped out to just call him. He's nearby. Should be here within 5 minutes.
Your Honor.
State your first and last name, spell vote.
Officer Nicholas Zuber, NICHOLASZUBER.
Thank you, Your Honor. Thank you for coming back, Officer Zuber. Sorry about that.
All right.
Are you currently employed?
Yes, with the Lansing Police Department.
How long?
Just over 10 years now.
What rank and assignment?
I'm currently an officer, especially with the Special Operations Section, SOS.
Taking you back to the date of August 27th of 2024, were you on duty and employed in that same rank and assignment?
Yes, I was.
Did you assist in a drug raid at the location of 909 East Kalamazoo Street?
Yes, I did.
At some point, did you make contact with the suspect, Eric Mask?
Yes, I did.
Did Eric Mask give you a statement?
Yes, he did.
Prior to giving that statement, did you advise him of his Miranda rights?
I did not, Sergeant Schleicher.
Okay. Were you present when he was advised of his rights?
Yes.
Did you hear him be advised of his rights? Did the defendant indicate a willingness to talk after understanding his rights? What did the defendant tell you about whether or not he knew there was drugs in his house and who owned them?
He initially stated he had no knowledge of that, but then later changed.
What do you mean?
Initially, he said that he had done nothing, had no knowledge, and then later on ended up saying that he was a drug addict and the drugs were his for that.
Did he say anything about whether or not he was involved in potentially distributing it?
He denied that.
He denied it.
Yes.
Did he say anything about, make any comments about what his level of involvement would be in such a scheme, small, big, anything like that?
He did say, while not being specific, he said that he's small time, that he's not a kingpin.
So he stated that he's small time, not a kingpin, but also tried to deny that he was involved in distributing.
Correct.
Okay. Did he say anything about any guns in the house?
He said there was a shotgun in the house.
So he admitted to knowledge of the shotgun, is that fair?
Correct.
Did he state whose shotgun that was?
He stated it was his shotgun.
Did he say anything about any other guns in the house?
No.
Did he in any way admit to throwing narcotics out of the window?
He did at one point when I confronted him that he'd been seen doing it, stated essentially, and pardon my language, oh, they did see that? Damn.
I assure you, damn is not the worst thing we've heard in this courtroom, but thank you. Did he say anything about knowledge of any specific types of drugs in the house?
He did, pardon me, he did specify heroin was thrown.
Anything else? No. Is there anything else about that statement or anything you did that you think this court needs to know about?
No, I do not believe so.
Thank you. I have no further questions.
Cross-examination.
Good afternoon, officer.
Afternoon.
All right. And Mr. Mask never once told you that he is a drug dealer, is that correct?
Correct.
And he never once said that he had any drugs in the house that he was going to give or distribute to someone else, is that correct?
That is correct.
And matter of fact, he told you that he was a user, correct?
Yes.
And he told you that he was an addict, correct?
Yes.
And he said that those statements more than once. Would that be a fair statement?
I believe he only said those statements once.
And you did not recover anything from Mr. Mask that would look like any type of list of people that he was potentially going to distribute drugs to or drug buys or anything like that?
I did not.
Thank you, officer.
No, Your Honor.
Thank you, Officer Zuber. Be excused.
Thank you.
Any further witnesses?
No, no further witnesses, Your Honor. The people were asked.
Is defense calling witnesses today?
No, Your Honor, we'll rely on the evidence presented. Thank you.
Proceed to argument.
Yes, Your Honor. Thank you. As Your Honor is well aware, we're here for a preliminary exam, which requires us proving by a probable cause standard that these felonies were committed and the defendant is the one who committed them. I advised the court at our last probable cause conference that there was an issue with the charging that I would be seeking to amend. I'm going to do that now as a part of the information and bind over, Your Honor. So I anticipate this might get a little confusing, but I will try my best to keep it all in order.
Okay, give me just a minute so I can make sure I'm on the complaint here.
I will start and go in order of the counts as charged, and then I'll do the charges that I'm adding at the end.
Okay.
So starting with count 1, Your Honor, controlled substance delivery or manufacture, more commonly less than 50 grams, more commonly known as possession with intent to deliver. Specifically, that count was just worded incorrectly, and frankly, we didn't have lab reports yet, so I think that was why. There was suspected heroin found at the scene. Methadone should have never been included in the charging language there. The lab reports have now indicated it is a fentanyl compound. So I would move to amend and have the defendant bound over on fentanyl, heroin and or fentanyl in the original count 1. Specifically for that charge, Your Honor, pursuant to jury instruction 12.3, I've proved 3 elements: that the defendant possessed the fentanyl compound, that the defendant knew he possessed a controlled substance, and that the defendant intended to deliver it to someone else. Your Honor, referring you to People's Exhibit number 10 that was up there with you, that's the photograph of the baggie on the outside. That baggie is what was picked up and tested at the lab. We also have testimony from Officer Booth about how many other baggies were found in this house, in the kitchen, where the scales were also found that tested positive for cocaine, based on Officer Meyer's testimony. That baggie that the fentanyl was in, I would argue, Your Honor, is the exact same types of baggies that were found all throughout the house and used with possession with intent to deliver. As Officer Booth articulated for us, the corners were cut off of every single one of those baggies. He's got somewhere between 20 and 30 baggies shoved in a cabinet with corners cut off near scales that tested positive for cocaine. Your Honor, the simple fact that he threw this bag out the window was an attempt to conceal evidence, or at least that someone threw it out the window was an attempt to conceal evidence that would show a consciousness of guilt. Regarding counts 2, 3, and 4 as charged now, Your Honor, those are all possession by a prohibited person for firearms. There are 3 counts because there was 3 firearms found inside this house. Overall, I'm sure there will be an argument made on whether or not the defendant was the only person to establish residency here, whether or not he had possession or control over the guns, the drugs, and everything inside. I think we can take that out at the knees, Your Honor, based on the investigation done by Officer Booth. They had surveilled this area for months, he said. They had information from a confidential informant that this particular defendant, Eric Mass, was the one who was living there and selling drugs out of there. He went by the street name of Jim Shoes. Then, after surveilling the home that Jim Shoes, also known as the defendant Eric Mass, lived at, the officers observed him coming in and out for several months, and upon entry, the only mail that was found, and stacks and stacks and stacks of it, somewhere between over 10 pieces, I believe Officer Booth said, all listed the defendant's name to the address of 909 East Kalamazoo Street. On top of that, there was only 2 other people found in the home. A small child, who I don't think anyone is going to argue possessed any of this knowingly, and a female. A female who told Officer Booth she didn't stay there, she didn't live there, and that she was going to collect her belongings on the way out. None of those included any of the cash, the drugs, or the money found, or drugs or guns found. There was 3 guns, a shotgun, a 12-gauge Mossberg, I believe it was, a .380 caliber Colt handgun, and a .38 special revolver, all found in the home. The shotgun, the .380, and the .38 were all found upstairs where the defendant was found. All of these were in his possession, and he even admitted to Officer Zuber that he owned the shotgun. The shotgun was his, despite having a prior conviction that Your Honor has been provided with that would make him ineligible to possess any sort of firearm. So we've got 3 guns that were recovered inside of the house that the only person we have residency evidence for is the defendant himself. That's how we get the 3 counts of possession by a prohibited person He also, again, Your Honor, I'll just reiterate, admitted to owning the shotgun. He just didn't claim the other 2 guns, although they were all still inside his house, that he was the only person he lived in. Regarding counts 5 through 8 as charged, Your Honor, those are all felony firearms to accompany the possession with intent to deliver in count 1 and the 3 PIP charges in counts 2 through 4. The defendant did knowingly possess a firearm. At the very least, with the way this is charged, he admitted to the 12-gauge shotgun. And that's how every single one of those felony firearm charges are charged, Your Honor. We have an admittance by the defendant himself that certainly satisfies probable cause that he knowingly possessed a firearm while attempting to commit these several felonies that are charged. Count 9, Your Honor, is controlled substance maintaining a drug house. That's a misdemeanor offense, so we didn't need to put proofs on for that. Where things will get a little more complicated, Your Honor, is with the added counts I'm going to be seeking today now, based on the testimony provided at this preliminary exam and the lab reports that we have. I will be seeking to add a count 10 for possession with intent to deliver cocaine less than 50 grams. That's pursuant to MCL 333.7412A4. Your Honor, the crack cocaine was true narc tested on scene. Cocaine is what the scales swiped back for positively. So we have 9.86 grams of cocaine, crack cocaine, found on scene in a baggie, and scales that tested positive for cocaine with it, next to, again, all the baggies with the corners cut. I believe that satisfies the elements for the defendant possessing crack cocaine, knowing that he possessed a controlled substance, and intending to deliver it for someone else. Frankly, the crack cocaine is what should have been charged in count 1, but I'm not going to go back and redo that. I will also be seeking to add a count 11 for methamphetamine or ecstasy pursuant to MCL 333.74012B1. That's for the pills that were sent to the lab, and we also have a lab report came back tested positive. Admittedly, I pulled the wrong photograph thinking it was some other pills, Your Honor, but we had plenty of officer testimony about these pills that were found in the house, how they were sent to the lab, and the fact that they came back, again, positive for methamphetamine. We also, circumstantially, once again, Your Honor, have a suspected drug house that a search warrant, Your Honor herself authorized on, was completed, conducted, a whole raid, baggies, scales, all found in same locations and similar styles. With, although there are statements about the defendant being a user, Your Honor, we have 9.86 grams of crack cocaine. We have 3.37 grams of, or 3.75 grams of what they suspected to be ecstasy and turned out to be meth, and at least 1.01 grams of fentanyl lab tested. I say at least because we don't know what else was thrown out that window or how much got lost, Your Honor. In terms of being a user or not, there is no evidence for that. The only evidence that is presented today was to support possession with intent to deliver of count 1, heroin and or fentanyl compound, an added count 10 for cocaine, an added count 11 for methamphetamine. And Your Honor, there was also testimony about plenty of firearms and ammunition found in the house. Frankly, again, these possession by a prohibited person ammo counts that I will now be seeking to add should have also been charged at the initial stages here. I was seeking to add a count 11 for possession by a prohibited person ammo for the 2 boxes of shotgun slugs.
Count 12.
Or count 12, excuse me, Your Honor.
11 was the ecstasy. Okay.
Right. So an added count 12 for possession of by a prohibited person of ammunition, first for all the shotgun. I'm not going to try to split that up, but there was 2 boxes of slugs found inside the house by Officer Schlegel. Officer Booth testified to them as well. Again, the defendant admitted to the shotgun. At the very least, by admitting to that, he's also admitting constructively and circumstantially to the ammo itself. I'll be seeking to add a count 13 for possession by a prohibited person ammunition for the box of .380 ammunition that Officer Booth testified to recovering in the house as well. That goes with, or at least circumstantially can be shown to go with, the .380 caliber handgun that he also should not have been in possession of. I'll be seeking to add account 14, again for possession by a prohibited person ammunition. This will be for the box of 38 special ammo to accompany that 38 special revolver that was found. And I'll be seeking to add an additional felony firearm count for every single one of the counts that I've added. So by my number here, we're at count 14, 5 added counts total. So we'll need a count 15, 16, 17, 18, and 19, all to be felony firearm to accompany each of the added counts. 1 for possession with intent to deliver cocaine, 1 for possession with intent to deliver methamphetamine, and 3 for possession or prohibited person in possession of ammo. With that, Your Honor, I think I've been confusing enough in all this.
Got it. Okay, Mr. Austin.
Thank you, Your Honor. Understanding, of course, that the burden of proof at this stage is relatively low, probable cause determination. However, it is a burden that the people must. Now, I'll agree circumstantially, there is, I think, a lot of evidence here that would support bind over on many of these counts. However, what I'm asking the court to focus on, I know the people's position is that as it relates particularly to the controlled substance counts, that it is clear, at least from the people's position, that Mr. Mask possessed those controlled substances and had the intent to deliver or distribute to someone else. And what I'm asking the court to do, Your Honor, if there is a probable cause determination on those, I'm asking the court to bind over on possession and not possession with intent to distribute. I think the facts as they were laid out, the testimony that came out, I think is insufficient and would be insufficient for a circuit court fact finder to conclude that Mr. Mask possessed those and had the intention of delivering them or distributing them or selling them to someone else. For the people in their argument to say that there is no evidence to support that Mr. Mask was a user or an addict, we did have evidence of that during this hearing. We had Mr. Mask's statement, and as the court is aware, statements, confessions by defendants are evidence. Yes, there were more than 9 grams of cocaine found. However, Your Honor, the other amounts of the controlled substances, the methamphetamine, I know they want to say is, I think, a little over 3 grams of that, but that amounted essentially to 7 or 8 pills. I think we don't need any advanced training, knowledge, or experience to conclude, at least by a probable cause standard, that would be more than likely what someone would possess, someone who is a user, someone who is an addict. Certainly the roughly 1 gram of fentanyl that was found is a relatively low amount, again, which I think would be indicative, just using our common sense here, of something that an addict would be possessing or something that an addict would be using. We didn't hear any testimony that all this time that they were surveilling Mr. Mask in this house, that they witnessed him in the act of drug transactions that he was buying or selling from other people. There wasn't any evidence found in the house that he had some type of list or journal that may indicate that. And I know they're trying to focus circumstantially on the evidence. Well, we have the evidence of the sergeant to say when there's a house that has drugs and guns and cash, ergo that's indicative of a drug house and someone who is likely going to sell or distribute those. But I don't think those facts in and of itself, Your Honor, are going to get them over the probable cause hurdle. Certainly, I think there are any number of reasons why Mr. Mask may have been in possession of those items without the intention of operating a drug house or with the intention of distributing those controlled substances. So if there is to be a bind over on those counts, Your Honor, I think it would be more appropriately bound over on possession of a controlled substance, but not possession with intent to distribute.
Further argument?
No, Your Honor, I think I've said enough. Thank you.
Okay, today was the date scheduled for preliminary examination. This information is for your benefit, Mr. Mass. The burden is on the prosecution. They need to establish that they have sufficient probable cause that a crime was committed, and then probable cause sufficient to charge you with the crime or the crimes. This is not a trial. They don't have to prove each element beyond a reasonable doubt. They don't even have to get close to that. They only need more than mere suspicion that the crime alleged or crimes alleged were committed. It could be based on circumstantial evidence, but it's based on the circumstances and evidence as is presented today at the examination. The court will also assess the credibility of the witnesses, and also make an assessment of the people's likelihood of success at trial. Again, you have as charged, a 9-count complaint, count 1 being controlled substance delivery manufacturing of cocaine, heroin. The people are asking to amend how it's charged to include possession with intent to deliver less than 50 grams of a mixture containing the controlled substance, heroin, and fentanyl, as opposed to methadone. And so we have testimony. I think it's not even a question at this point, based on the testimony, whether or not there's sufficient probable cause that there were these drugs found. I think the question now is the probable cause sufficient to the element of the delivery manufacture aspect. And then there is 1, 2, 3 counts of firearms possession by felon. Due to the testimony of the 3 firearms that were located, and the people are asking to add a count 10. Well, actually, there's also a 1, 2, 3, 4 felony firearms to accompany the first 4 counts, and then a count 9, which is a misdemeanor, so we don't need to address it. The people are asking to add a count 10, possession with intent to deliver controlled substance less than 50 grams of cocaine, and then a count 11, possession with intent to deliver ecstasy. As it relates to the probable cause for count 1, and whether or not there is sufficient probable cause for the delivery manufacturing aspect, I tend to agree with the prosecution's argument. The testimony, and I understand your statements, Mr. Austin, about there being statements to Officer Zuber about the defendant stating or indicating that he was a user, and maybe he is, maybe he isn't. But those statements also included statements, something to the effect that he's small time and not a kingpin. That's a term of art there. That's terminology there that would maybe explain why there's only a smaller amount of these substances located in, because he's at the end of the total. He's not the kingpin. He's got to get the bigger amounts from. This is not the time to raise hands or ask questions. Okay. This is the time to listen. And so if you had something to say, you would say it to your attorney. Okay. And so so that you don't say anything that could be used against you. Okay. So again, that statement, if said, would indicate that he's on some level of a totem pole, and essentially trying to cause the officers to believe that he's not higher up on the chain. But we also have to take that statement, as well as the statement that he allegedly stated that he was a user, and compile that with the other evidence. We're finding several types of illegal substances in the home. A defendant that is, or a subject that's allegedly throwing something out the window, admitting at least to, or acknowledging that substance that he threw out belonging to him. Also admitting of his knowledge of the drugs in the home. We have multiple weapons found in the home. We find large amounts of money in the home, and then scales with residue, but particularly the amount of baggies. And even when I look, and I asked the officer, so all of these, because it's nothing to have a bunch of sandwich bags in your home, but for the sandwich bags or the baggies to be cut in a certain form, I don't know of any other reason why anybody would buy. First of all, I hate buying two things: toilet paper and paper towel, because you just go through it so quickly and the cost, and then sandwich bags and things that you got to package things up. I'm not buying those and then just cutting them up for any other reason. And so for there to be a large amount, and I'm looking at this here in the exhibits, we've got large amounts of plastic baggies, and in one of the exhibits, looks like it might have been the contents of some trash, I'm not sure, even some rubber gloves, as if someone was doing some work. That's not common for users. That's common, and the court can speak to their own experience and before this court, and even in prosecution. This is common for distribution. Even if they just found the scales by themselves, I think that would have been sufficient enough for the court to believe, because typically when a user gets it, they're not taking it to a scale to test it, typically. Could happen, but it's not typical. But all of those things in conjunction are sufficient enough to find probable cause that there was manufacturing and or delivery of the narcotics. So the court is satisfied as to count one. That will be bound over. The testimony about 3 weapons being found, of firearms. I have a certified record signed by Judge Beverly Nettles Nickerson from April 5th, 2006. And so that would help support that the possession would be by a prohibited person if possessed by Mr. Mask. Any issue as to whether or not the contents of this home were Mr. Mask, or that Mr. Mask actually had residency there. Again, to reiterate, the testimony was that there was surveillance done for months. There was surveillance, including a confidential informant, providing that he or she could get drugs from this location from somebody by the name of Jim Shoes. And officers during the surveillance seeing the person that's been identified in court today as Mr. Eric Lee Mask entering that home multiple times, commonly over the course of that time period of the surveillance, and then the amount of mail that was found there, and officers testifying that they didn't find mail for anyone else there. Large amounts of mail. And then the defendant's located there. The only other adult that they testified being in the home made it clear that she didn't live there. So I think we have sufficient probable cause as to residency. And so as to counts 2, 3, 4, possession of firearms for the 3 firearms located by prohibited persons, the court is satisfied as to that probable cause. Those will be bound over. 5, 6, 7, 8 are felony firearms charges that will accompany counts 1 through 4, based on the testimony and the evidence that the defendant allegedly had a 12-gauge shotgun, which he allegedly admitted to in the home during the commission of these actions. I have a request to add count 10, possession of cocaine with intent to deliver less than 50 grams. There was testimony by Officer Myers that she assisted with the search of the kitchen, bathroom, basement. She located the 2 scales that had some residue which tested to be cocaine. And she also testified about making sure that it was True Narc, by the way, and that she checked the True Narc functionality to make sure it was operational and operating the way it was. She also tested what was found to be some cocaine. And so I also have a lab report, I believe, here.
That's right. My report doesn't include the cocaine.
The lab report does not
That wasn't
include cocaine,
sent to
but that I believe was True Narc.
Yes, sir.
And then there is a request to, so as to count 11,
We're on 11.
11, 10. I'm sorry, 10, not 11. Count 10 as to the cocaine will be bound over based on the testimony of Officer Meyer. Count 11 is for an added count of possession with intent to deliver ecstasy, and that will be bound over as well based on the testimony of the officer. And I have 12, 13, 14, which would be an added count or added counts of possession of ammunition by prohibited persons. That's all for the alleged ammunition that was located in the home, and I think that came in through the testimony of Sergeant Schlegel. Did I say that right? Yes.
Schlegel and Officer. You're on.
The officers testified, or Sergeant Schlegel first testified about the ammunition being located. He described ammunition for a 20 gauge that he said wouldn't necessarily fit in the 12 gauge, but still ammunition. Some slug and bird eye ammunition also located in the home. And then Officer Booth testified about ammunition being located at the residence. So those counts will be added and bound over based on that testimony. There is a request to add counts 15, 16, 17, 18, and 19, which would all be a weapons felony firearm to accompany the additional charges that have been added based on the testimony that those counts will be added to the complaint and bound over to the circuit court. I don't have a clue if the clerk's office is going to require a new complaint at this point. We'll let you know if it does. I'm gonna try to write it in there. Nonetheless, all counts as amended and added will be bound over for bind over date of September 25th. So that's the date the circuit court's gonna get the file from this court. You do not need to appear at circuit court on that date, okay, Mr. Mass?
Okay.
The next court date's gonna be a pre-trial. Make sure Mr. Austin has regular contact with you so that he doesn't have to go looking for you, okay?
Okay.
Remember, anything changes, it's your responsibility to update the court as well as your attorney. Okay, and the address we have for you is 909 East Kalamazoo, City of Lansing, Ingham County, State of Michigan. I forgot to put that on the record. The testimony was that the raid took place at that address. I'm making venue in this court appropriate. And your phone number ending in 2238, correct?
Yes.
Okay. On was set at 10,000 personal recognizance with random urinalysis testing 1 time per week. That will continue. Any additional matters for the record?
Nothing from the people, thank you.
Nothing additional back from Mr. Mask, Your Honor. Thank you.
Thank you. We spelled this right. Let me make sure I spelled that wrong. And
Your Honor.
give me the fact code for count 10.
It is 333.74012A4.
Okay, let's see, I count 11. Yes, please.
333.74012B1.
14.
74012B1.
And then let's see. Count 12.
Count 12. I believe it's the same fact code for the firearms count, Your Honor. I
Okay.
might be wrong, but it's 750.224F-A. Double check, Your Honor. I apologize.
I think you're right. I think it's under the same statute, it's just a different variable, but. It shouldn't be unless you've got an open. So. Oh, yeah. Yep, it is a different one.
I apologize, Your Honor. It is different for the ammunition ones.
Okay. So
750.224 F7.
F7. Sounds good.